folks, good morning. We are on the record today for the 28th Circuit Court here in Missaukee County. And we took care of a pretrial conference earlier off the record. So now we're moving to our docket call. And our first case today on the docket is People of the State of Michigan versus Tiffany Kathleen Jacobson. This is file number 25-3606FH. Appearances from counsel. To begin with the prosecutor, please.
Thank you very much, Your Honor. Attorney Robert Ringstrom, Assistant Prosecutor for Missaukee County.
Good morning, Your Honor. Allison Castle on behalf of Miss Jacobson.
Good morning, Your
you.
Honor. Lisa Kirsch-Satawa, also on behalf of Ms. Jacobson.
Thank you. Both counsel for the defense are appearing this morning via Zoom with permission by the court, and also join us this morning via Zoom from a Department of Corrections facility is Ms. Jacobson. Ms. Jacobson, are you able to see and hear the court?
Yes, Your Honor.
All right, thank you. Ms. Jacobson, again, I remind you that you have the right to be physically present in the courtroom, but it's my understanding that you waive that and are allowing us to conduct today's sentencing via Zoom. Is that correct?
Yes, Your Honor.
Thank you. Any objection to that, Ms. Castles?
No, Your Honor.
Also here this morning is Mr. Luke Blazak. He is the agent from the Michigan Department of Corrections who has prepared today's pre-sentence investigation report. Let's begin with the prosecutor. Mr. Ringstrom,
I have
any
had
amendments, corrections, or objections to make?
I have had a chance to be able to review the report. I personally do not have any amendments or corrections. I do understand that OB 12 probably should be scored less though.
Okay, so by the way, while we're waiting for you guys to come in, he told me you just had two challenges. So let's go ahead and talk about the first one. Ms. Castle, you're challenging offense variable number 12, as I understand.
Yes, as it relates to both offenses, offense variable 12 is for the contemporaneous felonious acts. In doing their calculations, probation calculated this based on possession of methamphetamine, felony firearm, and carrying concealed weapon. MCL 777.42 excludes felony firearms for being counted on for this variable. As a matter of statute, we believe that should have been properly scored as a 1 rather than 10.
All right, thank you. And Mr. Ringstrom, your response, sir?
I really don't have any objections to that, Your Honor. The possession of meth was what she had pled to was a lesser included of that, and I do know felony firearm can't be used. So
Okay.
I personally don't have any objections to it, and having it scored as 1 is okay.
All right. All right, thank you. All right, the court will grant that objection or challenge. We will therefore reduce offense variable 12 from 10 points to 1. And that's going to modify the total OV points for the first count, which is weapons firearm possession as a third habitual offender. That will reduce it down to 11 points. And I know there's going to be more. Just a moment, though. So that in and of itself would not change the OV level. Then we're going to look at count 2, which is the delivery, and that is going to modify OV 12 again from 10 to 1, and that will reduce the total offense variable scoring from 25 down to 16. And that offense, that would go down from a category, an OV level 3 down to an OV level 2 thus far. All right, Ms. Castle, your next challenge.
Next challenge is to the scoring of offense variable 14, the offender's role in the situation. Ms. Jacobson was scored 10 points, indicating that she was the leader in a multiple offender situation. Well, we don't dispute that there can be more than one leader. That's not what happened in this situation. The People v. Hayes is a Court of Appeals case decided in May of 2023, through which the court remanded for resentencing, where the defendant was scored as the leader under this variable, but his actions didn't show by preponderance of the evidence that he guided, directed, or otherwise was a primary causal or coordinating agent in the criminal transaction. That's what happened here as well. Ms. Jacobson was not a leader in the situation. The co-defendant, Miss White, was. Ms. Jacobson testified against the leader of this incident at the prosecutor's request. As she testified at trial and informed the police, she wasn't working with Molly White. She didn't provide Miss White with any controlled substances or help her to obtain them. The only basis for calling Miss Jacobson a leader is that she was driving the vehicle. It was her car. And so it makes sense that she would be the driver. She did not learn about Miss White's intentions of selling controlled substances until she was in prison and heard this from another inmate who was the intended recipient. But Miss Jacobson had no information, and I don't believe that there is a preponderance of evidence to establish that she's any degree of leader in this situation.
So far that it seems like a lot of that is going as to count 2. So let's talk a little bit though about count 1, which is the felony firearm. Mr. Ringstrom,
Yes,
let's
Your-
focus on that portion first. Go ahead.
We can focus on that portion as far as the felony firearm first, Your Honor. She is the one who had possession of the gun. She admitted it was her gun. Not that it really matters as far as it goes, but it was a loaded gun at that point in time and did have 2 bullets that were in it at that time. At the time of the pullover, she wound up passing that gun back to one of the passengers, Austin Ware, and basically told him, hey, hide this and everything. At the time, Austin Ware was actually charged with a felony firearm also because he was the one who had the gun and all of that stuff. So for those purposes, I do think that she would be considered a leader in that regard, because there was 2 people that were originally charged with it. It was her gun. She's the one who passed it back to him.
All right, thank you. Let's focus on that first argument. Ms. Castle, you kind of talked about the second count. Let's talk about count 1 though first, regarding the firearm.
Between those two, the passing back following Mr. Ringstrom's theory of how the case occurred, passing it back, there's no indication that she was the one who loaded or that she knew that it was loaded. Notably, when police encountered her, it was not physically in her possession. It was under a seat, I believe. I don't think that is enough to say that she's the leader of this multiple offender situation, as the facts don't support that to a preponderance standard.
She admitted, Mr. Ringstrom, she admitted to having the firearm and turning around and passing it back to somebody else, correct?
She wound up, I believe she admitted that at her plea process, that it was her gun, that she knew it was there and all of that. And
I remember her testimony. She did a very good job testifying. So, all right, the only thing here is when I look at it, was she the a leader, or did she just pass it back to a guy? I wasn't in the vehicle. No one here was, except for the defendant, was in the vehicle. Was she merely trying to hide evidence? Maybe. I think that's probably the best thing we could interpret. She definitely knew about the firearm. I don't buy the argument that she didn't know it was loaded. I mean, it was her firearm. So yeah, I don't buy that at all. Of course, why she was driving with a loaded firearm, unlawful, in a vehicle, carrying concealed, those are probably different arguments, and that I can take into consideration when I establish my sentence. So at least for count 1, I'm going to go and change that from 10 points down to 0 for OB 14. That's going to bring total points down from 11 to 1. That'll bring the OB level down from 2 to 1. And that makes the guideline range dip just a little bit from 12 to 36 as a half third down to a 9 to 34. Plus, we're going to be conservative and eliminate any appellate issue there. So now we're going to turn to count 2, and this is the delivery and whether or not she was or wasn't a leader there. Now, this is where Ms. Castle began her argument. I think she's already covered it. Mr. Ringstrom, go ahead on your response to that portion.
it was her vehicle. She was the one who was driving it. Testimony at the trial, which the judge heard.
Yeah.
They were all smoking it in the car and all that stuff. Ms. Jacobson admitted basically that she knew what was going on. And there was actually more than just possession, it seemed. It seemed like there was delivery going on as well.
And she testified that she was there when Miss White was on the telephone and said, hey, we need to go here, drive me here to go get the meth. So,
Yes. So I believe all of that could establish that she
Yeah.
was a leader along with Molly White, but
yeah, I mean, the other guys, the two gentlemen in the back seat, they were just along for the ride, getting high and going to the store. Miss Castle, anything to further say there in response?
I would just further state that her lack of knowledge in actually putting this all together for purposes of delivery. Yes, she was aware of the drugs in the car, but was she aware of Molly's plan to and then deliver it? Is being I believe that her being present while Molly was on the phone is insufficient to say that she was a leader, as Miss Jacobson wasn't on the phone. She wasn't aware of who she was speaking to. That's where that nexus is. It's not strong enough to say that she was a leader.
Can you become a leader by accessory in the middle when she found out? Because what she testified to was Molly was on the phone. Molly told her, we need to go here to go pick up more for deliveries. She testified that Molly told her what she was doing. And so then Molly only could have gotten there if Miss Jacobs had driven her car with Molly to the place to go pick it up. Isn't that a lot like a driver in a drive-by?
I think of that more as her being led. She was led to drive. She was taking
How was she led? Yeah, she's the one that had the gun. So how was she being led to drive? Did Molly White say, do it now or I'll hurt you? She just said, hey, turn the steering wheel to the right. And then Miss Jacobson turned it to the right. She couldn't have gotten there. She could have said no. She could have, because she didn't know Molly, is what she said. Miss Jacobson her testimony was very open. I thought she did a very good job testifying. She was, again, she came across very believably. All right, so hold on. Let me just take a look here for this moment, for a moment. Is the habitual only as to, that's only as to the count one, correct?
yes.
All right, thank you. So, but what I'm going to do is eliminate any appellate issue as to the scoring. I think the argument isn't the winner, but I'll grant it to eliminate that appellate issue. Therefore, that's going to reduce offense variable 14 from 10 to 0. Again, I don't buy the argument, but I'm going to do it by eliminating, looking forward down the road and eliminating that potential appellate issue, which again, I don't think is a winner, but I'll still. Therefore, we are now reduce the total EOB points from 16 down to 6. That changes the offense variable level now from the 2 that we had previously down to a 1. And that's going to give us a sentencing range of 9 to 23 according to the guidelines. All right, Ms. Castle, any other challenges to any other part of the PSI?
No
Oh,
other
I'm sorry,
challenges.
I'm sorry, no, you go ahead. I know. I was
No
gonna
other
say,
challenges, just some factual corrections.
all right, thank you. Mr. Ringstrom, before you say it, I'm gonna say it. We need to change the date on the page 2 or page 1 of CFJ 145. Plus, and she's currently serving a sentence, so while we would have to make an amendment on CFJ 145, page 2 under the jail credit section, that would change that end date from January 5th to January 5th to February 2nd. But again, the credit is 0, but I do think it's worth noting that the parenthetical of the 101 days, that's going to have to be changed to 128. Nobody criticize me if I did my math wrong. Well, you can criticize me if I did not do math well. But I think it's 128 days now. Okay. All right, Mr. Ringstrom, any other corrections, amendments, or challenges to make to the contents?
No, Your Honor.
All right, thank you. Ms. Castle, now you said you had some factual allegations or concerns. Go ahead.
Just really quick about, to make a correction about, her credit. It's my understanding that the prison sentence terminated on the 5th, so she would have been, entitled to credit from the 5th to today.
Okay. Well, actually, no. Did she enter? Hold on. I don't remember when she entered her plea. Just a second. Actually, if she entered her plea on November 14th. Well, but she's already serving a sentence. So how does she get credit when she's serving a sentence? I can take it into consideration. I'll agree with that. But I don't think she gets dates or time toward credit.
My understanding was that she completed her prison sentence on January 5th, so the time interim
So
from now to then.
I'm sorry, I missed that. You did say that. Mr. Blazak, did she finish her sentence?
It's my understanding that she's still in prison.
Well, I know she is. I can see her. But
So she would have,
if she had completed her sentence, she would have had to have been brought back here to Missaukee County Jail. Because there wouldn't be any lawful detention of her in the prison system.
yeah, I'm not aware
So-
that they would hold her for,
Let's take a quick look here at CFJ 284 section. And 1 second. So she was sentenced on September 26th of 2025. Do that right. 1 second. Sorry. Well, it'd be really close. She would had to have had she'd have to serve the minimum of 14 months.
that would be her earliest potential release date. which
Yeah,
doesn't
but
necessarily
if she
mean-
had 314 days credit as of the sentencing date on September 26th, she would have earned another 400 and I'm sorry, she would have earned another 96 days. Is that right? Yeah, 96 days. So that's 410. That would give us roughly 13 and a half months. So what I don't know is I don't know what the parole board did. Did they release her? Did they grant her? I don't know. So here's what I'll do. I'll leave it up to the defense or somebody to file a motion to modify an unlawful or invalid sentence if they give me proof that she actually was released by the Department of Corrections. Likely, she may have been, but if she had been, there's no way she could, I don't know how she would be able to be in prison. Oh, Miss White, I'm sorry, Miss Jacobson, you got your hand raised. If
Yeah.
there's something you wish.
Your Honor, I'm sitting on a deferral right now. My ASAT class, I just finished my midterm with all perfect attendance and all assignments, all correct. And I get off on the second week of February.
Okay, so you haven't done, thus far, you have not finished that sentence, is that right?
I finished the sentence, my parole class is over the second week of February, and that's when I'm completely done just with my class. So everything's done,
so-
just my class ends on the second week of February.
I think I understand them. So the point is, she's still serving a sentence. I will,
That's correct.
defense can make that argument for the court to take into consideration, which I'm able to. But whether or not she actually is entitled to credit, I don't think she is. All right, next, Ms. Castle. You said you had other factual.
Yes, yep, I do.
challenges.
I'm just trying to get notes back together.
Okay.
Under the personal history section of the first page, CFJ 145-1109, under personal history, it states that she's unemployed. She was employed as an in-home healthcare aide for her mother-in-law at the time that she was arrested. Upon release, she'll go back to this role.
Mr. Blazek, is it need to be changed, or technically she's unemployed, but she's, maybe you could call it, she's on vacation, or I don't know, permissive leave. I don't know what the right phrase would be, but
It says,
yeah, I mean, right now she's not employed, because, like, for instance, you could have somebody who is here for sentencing who wasn't in confinement, was on bond, and was employed. But right now, so I'll leave it as unemployed, but again, Ms. Castle, making that argument is a good argument for me to take into consideration. Again, when you look at the PSI program that they use, there are only so many choices they have. I can tell you that sometimes I wish they had an other, and you can type in, but, all right, thank you. You may continue. Next.
I would say I believe that's all. Aside from just corrections to the credit to reflect the time that's lapsed, since if the court's willing to consider that, if not, that can just be reserved for argument during elocution.
Yeah, that, we're just gonna leave that reserved for argument. Again, I can take that into consideration. Whether or not it is required to be counted as credit is a different question, and I rule that it is not. All right, allocution then, Ms. Castle.
Since Ms. Jacobson's initial interaction with law enforcement for this case, she's been entirely cooperative and taken accountability for her actions. She consented to the search of her vehicle, answered everything that the police officers asked her, and didn't give them any trouble otherwise. While in MDOC, she's had no tickets, no warnings, or otherwise any reprimand, and her pattern of cooperation continued as she willingly agreed to testify against the co-defendant about what really happened in this case. If the court's inclined to max Ms. Jacobson out at the top of her guidelines, she would be staying in prison with the people or with the person whom she testified against. And with there only being one women's prison in Michigan, her safety is a serious concern. Based on the sentencing guidelines, Ms. Jacobson is eligible for any additional custody ordered to be served in county jail, and Ms. Jacobson deserves this opportunity. While this case has been pending, she's been actively involved in rehabilitation and making life-changing improvements. She's made great progress with her ASAP program, as she mentioned. It's a 3.5-month intensive substance abuse class. She's had perfect attendance there, no tardies and no reprimand. She's also been working in the kitchen while at the prison. And she's additionally been trying to work towards getting her GED, but if she were to be released very soon, then she's also paid tuition for an outside GED program, not through the correctional system. Prior to arrest, she was the full-time live-in caretaker for her mother-in-law, who has been present at all of Miss Jacobson's prior court proceedings. Her mother-in-law has a variety of serious ailments and relies on an oxygen tank and Miss Jacobson's care to survive. By sentencing Miss Jacobson to a term at the county jail, her mother-in-law would be able to see her and continue offer her support to Miss Jacobson as she continues to succeed through sobriety and making these substantive improvements. Miss Jacobson has been clean from drugs for over 9 months now, and she has no intention of going back to that lifestyle. She intends to continue with her treatment and remain sober as she understands the negative impact that drugs have had on her life and the consequences that they bring. She advised me when we spoke about her PSI that a family member has been calling to get her involved in inpatient residential treatment following her release. If she's able to secure a bed at a residential treatment facility, we would ask that she be allowed to be released from custody into this treatment program to continue her progress. And upon release, Ms. Jacobson will have or will still actively be working towards her GED and intends to care for her mother-in-law for as long as she needs. She'll also have housing through her mother-in-law. So we're just asking that she be sent to the low end of the guidelines due to her cooperation with law enforcement and the steps that she's taken to not come before the court again in the future. If the court is willing to sentence her to a term of house arrest with GPS monitoring and any other conditions needed to ensure community safety and her compliance with conditions, this would allow her to resume providing care to her mother-in-law. But if the court's unwilling to allow this, we would ask that Ms. Jacobson be sentenced to a short term at the low end of the guidelines at the Missaukee County Jail.
Thank you. Mr. Ringstrom?
Well, I agree that after Ms. Jacobson got caught, she has been very cooperative. I agree that after she got caught, she has been doing all the services that is being stated and all of that stuff. I agree that she did testify for prosecution, that she, like Your Honor said, I believe she tested very honest. I believe that she did a really good job with her testimony. I believe that her testimony would have wound up potentially even supporting a delivery of meth instead, but that's besides the point. For that testimony, she got a really good plea bargain here as well. And that was something that we had considered at that time. I agree with all of that stuff. Ms. Jacobson, since she has got caught, has been doing a phenomenal job. She was still carrying around a loaded gun while delivering meth and all of that stuff, which is something that I don't think our society really likes as a whole. I'm gonna leave it up to the court as far as this decision, as far as what to do. I also agree, and I don't remember Ms. Castles had said it or not, but January 5th, she was supposed to have been sentenced and was unable to be sentenced because the attorneys had not got a hold of her. And that should have been brought up as far as some time that this court should consider as far as being less.
All right, thank you. 1 second. All right, Ms. Jacobson, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say?
Yes, Your Honor. I humbly come before you to express my sincere remorse and my commitment to change. There is no excuse for what I did was wrong. I'm truly sorry. I'm sorry to my family for leaving them with my responsibilities because of the choices I made. I want to make it right and make amends, and I'm willing to do whatever it takes to make this happen and be reunited with my family. I've worked diligently each day of my incarceration, preparing for success upon re-entry. I've developed new healthy habits and have a new mindset focused on future goals that I've created in alignment with my values so that I may earn my freedom and reunite to society with my dignity intact. That includes my ASAP, my Suboxone program, and my classes and working in the kitchen. I'm able to come clean and admit my wrongs and begin making amends. I take this very seriously. I've secured housing, unemployment, and have supports in place. I'm 100% committed to putting safety first and obeying the law. I will continue taking incremental action steps while remaining in recovery so I can change, so I can be the change I deserve to be.
All right, thank you, Ms. Jacobson. One of the interesting things about being a judge after having been a prosecutor and a defense attorney is that I no longer represent either party, obviously. And it's now finally when we get to sentencing that a judge applies his or her discretion. And in trying to reach a sentence, there are a lot of factors that I take in addition to those that are argued by the attorneys. First, I'm going to compliment you, as I already did earlier, You came in here during the trial with Ms. White. You were here without having counsel present, and you testified very credibly and very openly and thoroughly. And so the concept of taking it on the chin, you've done that. You admitted up to your errors, your bad choices here, and I welcome that. And the comments that you've made today stand out to me, believe it or not. Not a lot of people involved with this kind of criminal history and involved in this demonstrate to me what I really believe to be a sincere position, a sincere understanding, a sincere acceptance of responsibility. Normally, I just get the desperation. And so I compliment you on that. On the other side, there are a lot of factors. You know, not only were you not only were you carrying a concealed weapon, you were carrying a loaded weapon inside of a car, which is an unlawful transport. So there's another misdemeanor that you saved yourself from, the CCW, a felony. Plus you were operating while under the influence, putting everybody on that roadway in danger. You were smoking meth at the time. Everyone in the vehicle was handing the pipes or whatever it was, I forget now, back and forth. So there are at least 2 misdemeanors and another felony out there. Now, I know the felony was taken into consideration for OV-12. I got that. But I'm just highlighting that in addition to that OV-12, there were multiple offenses. I'll also note that had you been convicted at a trial for a Class B of delivery of meth, the minimum guidelines would have been at least 72 to 180. That is a presumptive prison sentence. So by doing what you've done, by working with your through your counsel with the prosecutor's office, you've done a very good job of bringing the maximum down from 480 months down to 120. Am I right? No, 50, 60, sorry, there we go. And bringing the minimum guideline range down from easily what would have been 10 years down to a guideline range somewhere hovering right around a 1-year sentence. So you've gotten a significant benefit here, and I appreciate that. Again, I appreciate what you had to do to get that. One moment. Actually, was it a 4th habitual offender or was it a 3rd? Actually, if it was a 4th, yeah, it was a 4th. Brought it down from, yeah, you brought it down from life.
She was charged with possession.
Yeah.
We didn't have any evidence of delivery at that time.
Which changes that guideline range from the 72 to 180, from 72 to 240. You've done a really good job here, taking it on chin, and you've also got a significant benefit. And you've been doing a lot of the right things at the prison. Now, the others, on the other side, I'll have to tell you that, you know, I speak at public events, or I write articles, or I participate in panel discussions. And the #1 concern that every citizen raises to me is this. You have this whole incident here was, other than sexual assault charges involving children, this is the #1 concern for every resident in Wexford and Missaukee County. Drinking and driving, but this one was driving while inhaling meth, rolling around with loaded guns, and delivery of controlled substances. So this is at the top of all the concerns for the people of this county. I hear it every time I talk to people about what's going on in the courts. Now, at the same time here, you've had a history. It's not overly extensive, but for a person who's 35, and there's a fairly significant amount. And it really kicked in the most, I think, in the last 5 or 6 years. That's when you had 2019, you had the assault resist the police officer. While on bond for that, you picked up a delivery charge, which was reduced down to a possession. And then while you were 9 months after being released from probation, you picked up another meth case. And while you were on probation for that, you made it about 7 months before you picked up another methamphetamine charge. And you picked up actually 2 probation violations in that file. Meantime, you had an unlawful use of a motor vehicle going on. Then entry number 9 of 11, that's when you picked up while on bond a receiving and concealing stolen property. There you also violated probation. Then 2023, while on probation, you picked up another larceny charge. And I'm going to tell you, one of the things that stuck out to me is there are multiple, they weren't drug charges, they're typically property cases. You had an embezzlement as a juvenile. You had 1, 2 different retail frauds, plus the receiving and concealing, plus the unlawful use of a motor vehicle in 2022, plus in 2023, another theft case. And then you pick up this case. And you picked up this case while on probation. So there's a balance here, and I've got to figure out what the right balance is. And again, I commend you that I believe you. I think you've gotten some corrective measures here. So let's focus on those positives. All right, one moment here. All right, the sentence of the court is as follows. The court sentences the defendant with 2 $68 state minimum fees, a $130 crime victims' right fund fee. And I'm not going to assess any costs, and I typically do even for those that are in prison, because I'll make payment of those conditional for parole. I'm not going to assess any fines based upon the same concept. I will, however, assess a $300 attorney fee. There is no DNA fee here because DNA was clearly already available. As to count 1, the weapons firearm, the court does within the discretion exercise to sentence the defendant as a 3rd habitual felony offender. However, I am going to sentence while I'm going to sentence the defendant to a prison term, it's going to be toward the bottom of those guidelines. So for this count, the court sentences the defendant to, I'm going to say 13. And then what I'm also doing here for the record is I'm taking into consideration that she's been sitting in jail or prison, even though she's not entitled to credit. I think what I'm doing is recognizing that and reducing it a couple months just in my mind. And so I think I'm already doing that. So that is 13 to 120 months. And the defendant receives the 154 days of credit. As to count 2, which is the delivery, anybody help and deliver drugs, you've got to expect a prison sentence. If you score a prison sentence, you're going to get a prison sentence here generally. I'm not saying I don't take into other factors in consideration, but that is the #1 concern for most of the citizens in these 2 counties. Delivery of drugs. 66% of my caseload is criminal, and of that 66, 2/3 of it, another 66, are just methamphetamine. So that's it. So here the court is going, and I'm recognizing the fact that this is the methamphetamine, and the court sentences the defendant to a range of 15 to 60 months, again with 154 days of credit. Have I missed anything, Mr. Van? Sorry, not Mr. Van. Mr. Van Amel, you are Mr. Blazak. Did I miss anything, sir?
Just clarification, I guess, whether those are concurrent or consecutive.
Oh, sorry. Yes, they run concurrent. Thank you. I apologize. I didn't mention that. They run consecutive to whatever sentence she has left to serve. That's keeping her in the prison right now. All right. So again, count one, 13 to 120, exercising the discretion to sentence as a third habitual offender. As to count two, it's 15 to 60. There is no habitual enhancement there, and each one she gets 154 days of credit. Mr. Ringstrom, any questions, or do you believe I missed anything?
No, Your Honor, I think you got everything.
All right, thank you. All right, Ms. Castle, is there anything you think I've missed?
No, Your Honor.
All right, thank you very much. All right, Ms. Jacobson, you will receive there at the prison 2 copies of one document. This document is entitled at the top, your notice of right to appellate review. You have the right to appeal the conviction and sentence. However, based upon the fact that there was a plea of guilty, any appeal must be done by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, if you do choose to file an appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of that document that will be provided to you and return to the court within 42 days. All right. Anything else, Ms. Castle?
No, Your
I'm
Honor.
sorry, Ms. Satawa, you took off your mute. Go ahead.
I did, Your Honor. I just wanted to place on the record that Ms. Castles did visit Ms. Jacobson in person and reviewed the PSI in order to
Great.
ensure its accuracy. I don't believe that that was placed on the record.
Oh, no, and thank you very much. I appreciate that. I think it's always a good thing for counsel to comment upon. All right. While I've given a sentence that does involve a prison sentence, it is at the bottom end of toward the bottom half of the guidelines, which I think because of how she's handled this case, how she's dealt with the prosecutor's office, the police, how she's helped resolve the other cases, she has saved herself easily another 5 to 6 years. That may be something that's lost. I want to highlight that. The next thing is Ms. Jacobson, you may not feel it, but trust me, all right, maybe besides Ms. Castles, you're a lot younger than everybody else here involved in this case. So you got a lot of life to live. And that's what I'm trying to get to, is the positive. You may not feel it now. That's the positive. You would have been sitting there until you were probably 42. But you'll be out well before that. You've got a lot of opportunity, maybe to come back here to the community, maybe and be a peer recovery coach, things like that. There's a lot of ways to look at this, and turning it into a positive as a learning lesson is what I really hope that you do. I really hope that we never see you here in a jumpsuit, but I do hope that you're always welcome to come by and chat. I have coffee with people on occasion, and I always like to hear about positivity. So that's why I want to turn this into positive. All right, thank you, folks. We are adjourned.
Thank you.
Anyone? No? Okay. Well, if you tell me what case you're here on, I'll try to call it. I'll call it next, then, okay? Sure. All right, Mr. Booker, good morning. You're here for first appearance, accused of 3 charges. You're accused of 1 count of resisting an officer with violence, 1 count of possession of cocaine, and 1 count of possession of more than 20 grams of marijuana. Mr. Booker, I read the complaint. There is probable cause for at least 2 of the charges. I had some questions about the marijuana case based upon the type of test done. And so I sent a text to the state and defense this morning about that. Let's see what their position is on that, as well as bond issues. Mr. McDaniel, anything?
Just what you said, Your Honor, nothing else.
Mr. Mitchell?
Your Honor, we probably will get in contact with law enforcement on that, but we just, if you want to go ahead and set a bond analysis, we could set an ROR on the marijuana charge. But as for the other 2 charges, since you're finding PC, we just request he be subject to random UAs.
Since his allegations are over 20 and because of his history, I wouldn't do an ROR. I would either hold him unless Mr. McDaniel wants to stipulate for first appearance purposes just to get a bond set. Okay.
Okay.
All right. So Mr. McDaniel is stipulating for first appearance purposes to a probable cause. And here's why, Mr. Booker. He doesn't want me to hold you 24 hours without you having a bond, which is one of the options. That's what I would do normally because your history, because it's of over 20 grams charge. But to get you a bond set today, Mr. McDaniel is stipulating today only just to get you a bond set. He's not waiving any rights of yours. So giving that fact, you've got the 3 felony charges. They're all third-degree felonies. Your bond's gonna be $5,000 each. Mr. Booker, your total bond is $15,000 cash or surety. Cash or surety, Mr. Booker, means you can go through a bondsman. You do not have to come up with all the money. You do have a condition of random urinalysis. That's a condition we put on every case. It's a drug-related offense or charge. So what that means is you can be drug tested at any time. Be aware of that. If you have something in your system that you don't have a valid prescription for, that could violate your bond. So, Mr. Booker, your bond is $15,000 cash or surety, and you will get a chance to use the phone in just a few minutes, sir, to try to post the bond. If you post the bond, you'll be released immediately. If you don't post the bond, the public defender's office will be in contact with you. Do you have any questions, sir?
No, sir.
Have a good day, sir.
Judge, what will be the court date?
Thank you. March 3rd. Thank you for reminding me, Corporal. March 3rd at 8:30. Kendrell Brown, and is it parents that are here? Parents? Mom? Is his mom? Mr. Brown, good morning. Mr. Brown, your mother's in the courtroom. Mr. Brown, you're here because you're accused of 1 count of violating the terms of your state probation. There is a no bond warrant that's already been signed by the circuit judge. So all I'm going to do this morning is I'm going to arraign you. What that means is I'm going to get you a lawyer appointed if you're asking for one. So we can get your lawyer on board. Mr. Brown, would you like to have an attorney appointed to represent you?
Yeah.
I'm going to appoint the public defender's office of the 14th Circuit to represent you. Listen to Mr. McDaniel. He's going to tell you when the court date is, and then we're going to see if you have any questions in just a moment. Mr. McDaniel.
No, we're going to plead not guilty, said on the March 5th court docket, and advised him the attorney from the public defender's office if he's in prior to that date.
So March 5th will be your court date. Mr. Mitchell, anything?
No, Your Honor.
Mr. Brown, an attorney with the public defender's office, probably Mr. Green, or could be Mr. Sims or Mr. Blunt. One of those attorneys will come see you at the jail before the court date. Do you have any questions, sir?
No.
Have a good day, sir. In the courtroom, do you have any questions, ma'am? Have any questions?
We're aware of his mental condition, Your Honor.
So the only allegation is that he failed to attend treatment sessions from life management. That's the only thing he's accused of doing. So Mr. Guy Green will be his attorney most likely.
We're using multiple attorneys, so I don't want to say who.
Well, that's who was doing them until recently. Now it's kind of split up between a couple of different attorneys. But the public defender's office behind us, you may want to check with them and see who's going to be going to see him and make sure they're aware of everything. You think you're already aware of it, though?
They should be. I'm aware of it, so I would think that they would be aware of it, but it wouldn't hurt to let them know.
So you may want to contact the public defender's office, ma'am, and find out who's going to be his attorney. Okay? Thank you. Yes,
I
ma'am.
have no doubt Judge Garcia is aware of it.
We have Zachary Doolittle next. Mr. Doolittle, good morning. Mr. Doolittle, you're here because you've been accused of possession of more than 20 grams of marijuana. Mr. Doolittle, there is probable cause in the complaint. I'm going to appoint the public defender's office for first appearance purposes to represent you. I'm going to ask that you listen to your attorney, Mr. McDaniel.
Your Honor, we just asked the court to consider conditional release. I think he lives in the area. He works here. I don't want to say what he does for a living, but he works here. We just asked for conditional release.
The only hesitancy I have about the conditional release is he has no history according to what I've got, but it's allegedly 56 grams of marijuana, which is
what a misdemeanor would be amount, or I guess triple what a misdemeanor amount would be, but it's still not the old days it may have been a lot, but most states that's personal use, but not in Florida. I'm not saying it is in Florida.
56 grams is personal use in a lot of states?
Yeah.
Really?
Yeah.
Mr. Mitchell, what's the state's position?
I mean, this is Florida, not Las Vegas,
I'm not
but
saying it is. I'm just saying he's got no history and
I
he's telling me he's got a medical card for it. I'm not suggesting at all that what he admitted to is legal under a medical card at all.
I think regardless of whatever it is, we just request he be subject to random UAs.
What is the state's position on bond versus release, Mr. Mitchell?
We would request a bond, but it doesn't have to be a felony bond.
Fair enough. Mr. Doolittle, there's two concerns that I have about a conditional release. You have no history, which is great. The amount of marijuana is one concern, and then there's an allegation regarding you allegedly attempting to stop people with flashing blue lights on your bumper. Now, you're not charged with that. That's in the probable cause affidavit that you were allegedly doing that. So I'm not sure why they didn't charge you. Maybe they didn't feel like they had enough evidence to do so. What I'm going to do is I'm not going to give you a conditional release because of the amount of marijuana and the blue light allegation. What I am going to do is just set you a misdemeanor bond. This is not a misdemeanor you're accused of, but I'm setting you the equivalent of a misdemeanor bond, which is $2,500 cash or surety. That means you can go through a bondsman. If you go through a bondsman, what they charge you is something you negotiate with them. Usually it's around 10% of the bond. 10% would be $250 if they charge you 10% to get out. Mr. Doolittle, you also will have a condition of random urinalysis, which means you can be drug tested at any time upon a court's request. So be aware of that possibility. If you take a drug test and if you got a medical marijuana card, having THC in your system may be okay, depending upon the amount, the concentration, and so forth. It gets complicated. Mr. Doolittle, you will also be given a notice for your court date, which will be March the 3rd at 8:30, and you'll get a chance to use the phone in just a few minutes, sir. Do you have any questions?
Yes, sir.
Have a good day, sir.
Oh, good.
Let me see, Donald Middleton. Mr. Pendleton, good morning. Your situation is the same as that of Kendrell Brown, who I saw earlier. You're accused of violating the terms of your probation. The circuit judge has signed a no bond warrant. Mr. Pendleton, that means I'm going to go ahead and get you arraigned this morning. If you want an attorney appointed, we're going to go ahead and get that done today and get your case moving. Mr. Pendleton, would you like to have an attorney appointed to represent you?
Yes, sir. That'll give me a chance to talk to Stephanie and everything, correct?
Well, that'll be the first step. They'll get the ball moving. That's right. So I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel. He's going to tell you the court date, and then we're going to see if you have any questions in just a second. Mr. McDaniel.
Your Honor, plead not guilty. Court date will be March 5th, and I advise an attorney to come represent him, talk to him about this case.
Thank you. Mr. Mitchell, anything?
No, Your Honor.
So March 5th, an attorney with the public defender's office will come and see you, and that's who you want to talk to about talking to. We say Stephanie. I'm assuming you're talking about Ms. Colbert, the placement specialist.
Correct. To go across the road.
Yep. Okay. So they would talk to your attorney about that, and they'll contact Miss Corbett, and she may already know about it. She watches First Appearance a lot of days, so she's very proactive. She may come see you at the jail and talk to you about it before then. Okay.
Yes, sir.
Have a good day.
You as well.
Levi Gilly. I need to see Mr. Gilly.
Yeah. His sister does not live there.
Mr. Gilly, good morning. Mr. Gilly, you're here for First Appearance. You were seen this weekend. Good morning. You were set a bond of $1,000. You're being seen today because this is a misdemeanor offense. It appears you have no prior criminal history. I'm appointing the public defender's office to represent you for First Appearance purposes. Please listen to your attorney, Mr. McDaniel.
Your Honor, Mr. Gilly is going to accept the PTI for 6 months, pay a $370 fine, $95 in restitution. You know, his sister does not live at the house there with his parents, and I guess he kind of lives outside. I've talked to him about it. He's going to find a job, find something to do, living in a tent outside or whatever. He's going to have to do something.
So, Mr. Gilly, we've got to make sure we're on the same page on where you're going to go, first of all. So I can't let you have contact with the alleged victim, Miss Gilly, your sister, unless she wants it. So she does not live there, correct?
No, sir. She lives, no, she don't live there.
Okay. And you live on that property. Is that the same property your parents live on?
Yes, sir.
But you live outside in a tent or another structure, is that right?
I live in the house outside. I don't live in no tent.
Oh, there's another house out back then that you live in, right?
Yes, sir.
And just to make clear, your sister doesn't live in that home or the other home where the parents live. She's not at that address at all.
No, sir, she is not.
Okay. And the PTI program that Mr. McDaniel went over with you, is that what you want to do?
Yes, sir.
Mr. Mitchell, is that agreeable with the state?
Your Honor, I've discovered this while we were looking this up. Mr. Gilly does have a review case that's out there for 2 counts of domestic battery against the same victim in this case and another victim. And I just sent an email to our victim advocate to get in contact with them, see if they're okay with just going forward on the PTI on this case, but the state would be requesting a little bit more time to see if we can sort of lump them together.
So there's a couple things we can do. we can just do a conditional release today and come back to court and deal with it later. The other option is to go ahead and do the PTI with the understanding that the state may be asking for additional conditions to be added, if that's appropriate from the state's perspective. Either way, it's your call. So what would you prefer to do, Mr. Mitchell?
The second option is pretty good.
So, Mr. Gilly, you need to understand, we're going to go through this PTI if this is what you want to do. But
Yes, sir.
you have 2 cases of battery that are in the state attorney's office they've not made a decision on yet. So they may come to you next week and say, we want to add a condition, no contact with blank, somebody other than your sister, because the no contact with your sister is going to be in there already. But then you
Okay.
have an additional condition of no contact with somebody. Now, you may say, no, I don't agree to that, in which case they will charge you with that battery. Or you may say, that's fine, I'll stay away from that person too.
Madison
I will.
Andrews, you know
Matt-
Madison?
Some person named Madison
That was my girlfriend.
was your girlfriend, so I'm assuming you're not together anymore?
I guess not now.
Okay, I don't know. I just know that there's a battery complaint involving her. So I'm
I
not
never knew
putting a
about
condition of
that.
no contact right now on her. I'm just telling you, if that happens, that may be the person that doesn't want contact. I don't want to speak for her, but right now
Yes, sir.
that condition doesn't apply. But if that happens, that may be coming in the future. Okay.
Okay, yes, sir. I understand.
So I don't, she may be fine now with a contact. I have no idea. And you haven't been arrested or charged with that. The state attorney's office is just reviewing a complaint. Okay.
Yes, sir.
Okay. So as far as the PTI in this case, this is what you want to do, right?
Yes, sir. But does
Mr.
that
Gillen,
mean I
I'm
will
gonna show
get
you a
out
case
today?
Yes, sir. I'm going to show you a case referred to the PTI program for 6 months. Condition, no contact the alleged victim, your sister, standard court costs and fines of $370. And what were the other conditions, Mr. McDaniel, Mr. Mitchell?
Miss Williams and I were discussing a retail theft, but this isn't a retail theft.
It's not a retail theft.
No.
$95 in
condition.
restitution,
Yes.
which brings up another question. You're the expert on this, the arrest. There is an exception to a warrantless arrest for retail theft. I don't know there's an exception to warrantless arrest for petty theft. Mr. McDaniel?
This clearly could have been charged as a felony, Your Honor. I mean, this is not even this is something different, doing fraud by, internet use and things like that. I think the
So there's
officers, I don't see no issue.
You don't have
with
any
it at all.
problem because they elected to charge him with a misdemeanor when they could have charged him with a felony.
Absolutely.
I just want the officer to be aware that from the misdemeanor perspective, this is not a case he or she can make a warrantless arrest in, Mr. Mitchell. So,
Based on my understanding.
yeah, I don't think he can. It's not a retail theft, and it didn't occur in his presence. So would you please talk with the officer? And if I'm wrong, please let me know that. But I don't think they can make an arrest in this situation. But Mr. McDaniel's not complaining because it appears they could have charged him with something more serious.
Correct. And because they could have charged him with that, I think arrest is not going to get a complaint by me.
Thank you.
And
Thank
Mr. Gilly, I just going to advise you, stay away from Madison for at least for a while. I don't know what's going on with that. Obviously, no contact with your sister, but it'll help your cause out a lot if you stay away from Madison also. Don't talk
Yes,
to her,
I
don't
will.
call her, just don't stay away from her.
Mr. Gilly,
Yes,
what's
sir.
going to happen next? They're going to let you use the phone in case you need to set up transportation and call whoever you wish, except the no contact people. With
call
no
my
contact
mama and tell
person,
her
you've
to
heard
come get
Mr.
me.
McDaniel's suggestion, so you'll get to use the phone. After you use the phone, they're going to let you get dressed in your regular clothes. They're going to bring you to the courthouse because that's where the conditional release office is at. That's where the PTI office is at. When you get to the courthouse, you'll meet with Mr. Goodson or Mr. Ham, one of the conditional release PTI officers, and they'll go over the PTI with you. They'll make sure you don't have any questions that are unanswered, and then you'll be free to leave. Mr.
Thank you.
Mr. Gilly, if you call friends or family, tell them you can be picked up at the courthouse in about 30 to 45 minutes. Do you have any questions?
No, sir. Everything sounds good.
Have a good
Mr.
day,
Gilly,
sir.
let me remind you, if your sister comes to your parents' house, you've got a place out back. You don't need to be around her, okay? That means you need to be away from her. If she comes
Yes,
over,
sir.
you need to go the other way. You understand?
Yes, sir, I will. Yes,
All
sir.
right.
Thank you.
Thank you. Sandor Kirkland. Mr. Kirkland, good morning. Mr. Kirkland, you were first appeared this weekend for a charge of aggravated battery, and the judge held you with no bond. Mr. Kirkland, what we do in a lot of these outer counties, these rural counties, is we put a time limit on that no bond hold. The reason we do that is we want the probation office to go ahead and decide what they're going to do instead of you just sitting
Yes,
there
sir.
for weeks and weeks with no bond. So we put a 7-day time limit on it. So the only reason you're being brought back today is to put that 7-day time limit on the VOP. That 7-day time limit starts today. It's always the first working day. after the arrest. So I'm going to ask Mr. Mitchell to notify the probation office of the arrest. They have 7 days to get a warrant if they want to seek one. And Mr. Kirkland, if they get a warrant, you'll come back to first appearance within 7 days. And that I'll tell you if that judge that signed the warrant put a bond on it or not. Mr. Kirkland, if there's no warrant in 7 days, you'll come back to first appearance next week, which will be next Monday. And if there's no warrant at that time, I'm going to release that no bond hold and you'll be free to post bond on the new charge. That's pretty rare, but it's possible. Mr. Kirkland, do you have any questions?
No, sir, I don't.
Have a good day, sir.
Yes, sir.
Corporal, I think that's it for first appearance purposes. Anything from the jail I may have missed?
No, sir.
Go to Kalkaska County, Michigan. This is Judge Mertz. And this is interesting because the defendant is appearing from space jail this morning.
People versus Griffith. This is file number 255101. Mr. Dennis, you can go right to the podium there. We're going to take care of one thing before we start yours. The record should reflect Mr. Griffith was present today by video from Wexford County Jail. If I could have both counsel put your appearances on.
Good morning. Thank you, Honor Ravi Gurumurthy. I'm appearing on behalf of Mr. Griffith.
All right, this is set for a final status conference today. We do have trial set to begin in this matter on February 18th. This is also the plea cutoff. So this is the last date to enter into any plea agreement prior to trial. Mr. Gurumurthy, have you been able to discuss that with your client?
I have, Your Honor, and we've had some extensive discussions. I've had some extensive plea negotiations with Mr. Ziegler's office. We've reached a resolution. My understanding is Mr. Griffith would enter a plea of no contest to 6 counts of felonious assault. The remaining 9 counts in the felony information would be dismissed. There is no sentencing agreement, Judge.
Okay, and what would be the reason for the no contest plea?
A potential civil liability, Judge, and Mr. Ziegler and I did previously email Ms. O'Rourke at your office a copy of the transcript of the preliminary exam that establishes factual basis for the no contest plea for those 6 counts of felonious assault.
All right, thank you. Mr. Ziegler, is that a correct statement of the plea offer in this case?
It is, Your Honor.
Okay. Mr. Griffith, were you able to hear all of that?
Yes, Your Honor.
And have you had an adequate opportunity to speak with your attorney about this plea agreement?
I have, Your Honor.
And is that how you wanted to proceed today?
Yes, Your Honor.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Griffith, are you currently on any kind of probation or parole?
No, Your Honor.
All right, and you understand that for each count of felonious assault, that the maximum possible penalty you could face would be up to life. I'm sorry.
4 years and or $2,000, Your Honor, for felonious assault.
4 years, sorry.
That's correct, Judge. It's 4 years and a $2,000 maximum on the 4-year count.
Okay, so Mr. Griffith, you understand that that is the maximum possible penalty for each of those counts?
Yes, Your Honor.
With that maximum possible, is there any, Mr. Gurumurthy or Mr. Ziegler, are either of you aware of any potential consecutive sentencing sanctions in this case?
I am not, Your Honor.
And neither am I, Judge. There should be no consecutive sanctions in this case.
Okay. So, Mr. Griffith, with that maximum possible penalty in mind as to each of those charges, what is your plea here today?
No contest, Your Honor.
All right. Right now you have certain rights, Mr. Griffith. I'm going to go through those rights with you here on the record. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand that you have all those rights?
I do, Your Honor.
And you understand that you're going to be giving up and waiving all of those rights by pleading no contest, and you won't have those rights anymore, including that right to have a trial.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of that appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead no contest?
No, Your Honor.
Has anyone promised you anything other than what we've said here on the record today?
No, Your Honor.
And is it your own free choice to enter this plea?
Yes, it is.
All right, so based on the stipulation of the parties and the stated reason of the potential civil liability, given the nature of the charges in this case, the court finds that that's an adequate basis to accept a no contest plea. I also did receive, as indicated by Mr. Germer, the transcript electronically. I had a chance to review that transcript prior to the hearing today. Mr. Ziegler, have you reviewed that transcript?
I have, Your Honor.
Would you agree that the testimony contained within that would establish a factual basis for 6 counts in this case?
I do.
Mr. Germerthy, have you done the same?
Yes, sir.
Would you agree as well?
And I would.
All right. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Germerthy, are you?
No.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this no contest plea?
Yes, Your Honor.
Mr. Germerthy?
I concur.
Thank you. Mr. Griffith, the court finds that your plea is knowing and voluntary. I'm satisfied based on my review of the transcript as well as the stipulation of the lawyers that there is testimony in that transcript that would establish a factual basis for a finding that you are guilty of 6 counts. The court will accept your no contest plea as to all 6. We will set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, you'll be contacted by the probation department for a pre-sentence investigation. Once they prepare that report, you'll have an opportunity to go through that with your attorney, and then we'll set this for a sentencing hearing. Do you have any questions about how we're going to proceed with your case?
No, Your Honor.
And then finally, the court will adjourn the trial dates currently set for February 18th through the 20th in light of the plea here today. Mr. Germerthy, anything further on your client's behalf?
Two things, Judge. One, I would like to be present at the pre-sentence interview with my client. I know Ms. Wagner and Ms. Wilkeron, so I know one of them will reach out to me to schedule that, but I wanted to just inform them that I'd like to be present. Second is, Judge, I'd like to argue bond on behalf of my client. Bond with the original charges, understanding that that's what he was charged with, was set, I believe, at about $8 million. Mr. Griffith has been cooperative. He has accepted a plea to the felonious assault. I would ask that bond be modified accordingly. Mr. Griffith has no prior criminal record. I've been in contact with Mr. Griffith's wife, who lives in Kalkaska County. He has 2 minor children. I think one is 2.5 and one is about 6 months old. Mr. Griffith is not a flight risk. His property is in Kalkaska County. He is a resident of Kalkaska County, has local ties to the community through friends and other individuals through his homestead. Certainly, Mr. Griffith is not opposed to being on any sort of GPS monitoring or tether. He would abide with the no contact orders that the court would impose. There is no concern of drugs or alcohol with Mr. Griffith, but certainly if the court requires Mr. Griffith to comply with any pretrial services, he would do so as well. I would argue that in this matter, that the bond be set at $20,000, 10% to secure Mr. Griffith's appearance at sentencing. And Mr. Griffith is going to appear at sentencing. I have no issues with him being a flight risk, Judge.
Mr. Ziegler?
Your Honor, I think regardless of whether the plea is to the 9 felony counts that were initially charged or the 6 felony counts that he's pled to, it's clear that this is a serious offense. It's an offense that involves endangerment of the public and of the victims particularly. I do agree that a bond of 8 million cash or surety probably would not have been warranted had we started with just counts of felonious assault, but that's not how this case has developed. I believe, and the guidelines are always subject to the court's approval, but my belief is that the guidelines for the felonious assaults are going to be 5 to 23. It's very likely that Mr. Griffith will still have to do some additional time, depending on what the court sentence is, obviously. And so I don't think that a modification of bond at this time is warranted.
All right, thank you. Mr. Griffith, there's a number of things that the court has to take into consideration when it comes to the amount and conditions of bond. Number one, I think there's been a plea in this case, so we're no longer in a pre-trial type posture here. Mr. Griffith has pled guilty, so it's no longer a question of guilt or innocence in this case. I mean, he's pled no contest, but he's accepting responsibility for these crimes. So I don't find that Mr. Griffith would be entitled to pretrial release at this time regardless. But the court finds that given the nature of these crimes, which are assaultive, there are numerous offenses here that Mr. Griffith's pled no contest to. Regardless of amounts or conditions, the court finds that it would be in the interest of public safety to have bond remain where it is pending a sentencing hearing in this case. The court also agrees with Mr. Ziegler in terms of a potential sentence. If those are the guidelines, it's likely that Mr. Griffith is just going to continue to accrue credit for a sentence that he would ultimately be required to serve. So for all those reasons, the court finds that bond should be, the motion for modification of the bond should be denied. The bond will remain as set. And again, we'll set this matter for a sentencing hearing at the court's next available date. So aside from that, Mr. Gurmurthy, that sentencing hearing will be in person. So I'm going to request Mr. Griffith will obviously be brought here. I'm going to request that you're present here for the sentencing hearing as well, in case he has questions or needs to go through things with you. That'll be easier to do if you're here.
Yes, sir.
In light of the original information, Mr. Ziegler, and the plea agreement here, I am going to ask that you prepare an amended information with the new counts added to that, so that just given the nature and the number of charges here, I think it'll be cleaner for the file as opposed to trying to just do that for the record. Can you get that filed with the clerk's office today?
I believe so, Your Honor.
Okay. Mr. Ziegler, anything further from your standpoint?
No, Your Honor.
Mr. Gurmurthy, anything further today?
No, sir. Thank you.
Okay. All right. Thank you. That's all for this hearing today.
Thank you, Judge.
Okay, a thank you to Austin for finding this. I'll read it for those of you who haven't seen it in the chat. He found context for us that explains an $8 million bond, and it explains why they put this guy up in space jail. On Labor Day 2025, Griffith allegedly fired approximately 25 to 30 rounds from a firearm at a group of 8 off-road vehicle riders passing by his property. As Great Granny put it, a mass unaliving attempt. So, some serious stuff. So thank you, Austin, for finding that and providing us some context. It makes all sorts of sense now as to why he's up in space jail. They want him as far away as can be. Looks like Judge Oakley has returned. Let's go back there.
Good morning, Your Honor. Jacob Leckie appearing on behalf of the people, P88400.
And good morning, Your Honor. Good morning to your staff. Neighborhood Defender Service by Ken Riggins, P82125, on behalf of Mr. Dennis McCarter, who is here via Zoom. Mr. McCarter, can you state your name for the record, please?
Dennis McCarter Jr.
Thank you, gentlemen. Your Honor, the date and time set for a probable cause conference matter. I have the bulk of the discovery. I did indicate this is a police officer resisting instruction causing injury to a Nathaniel Sims. I don't have any medical documentation for Mr. Sims.
Good. I'm Dr. Renetta. I'm a cardiology doctor, cardiology fellow.
Go ahead.
What's been going on? I'd love to, sure.
Try it again.
Your Honor, again, Your Honor, again, today's the date time set for a probable cause matter. And this matter, I do have the bulk of the discovery. I do have digital, I do have paper. However, this is a police officer resisting, obstructing, causing injury to an officer, Nathaniel Sims. I do see that Mr. Sims did go to the doctor's office for this injury. We'd like to have a copy of any diagnoses that the office made.
Mr. Leckie?
And Judge, I can't guarantee that by exam next week, but we will start the request. As you know, there are, HIPAA laws that are involved and require me to get a disclosure or a permission from the officer, so it's going to take some time. However, we have enough to proceed to exam, Judge.
All right, so we're gonna leave the exam 10:30 next week?
Yeah, the only problem I do have a trial schedule next week for Tuesday, Wednesday, and Thursday. It may be done by Wednesday.
This exam is scheduled Tuesday.
Yeah, it's Tuesday, Wednesday, and Thursday at the trial.
Okay, so are you asking for, I'm confused. I thought you guys wanted to leave this date on and we were gonna talk about bonds. So now you're telling me you want to adjourn the exam date?
No, I said I wanted to, I was asked, did I want to go on the did I want to leave the date? And I said, no, I wanted to go on the record because
Okay, so you need another day for exam?
I do need another date.
Okay, all right. Have you fellas talked about when you're both available on a Tuesday?
Judge, it doesn't really matter for me, but I thought we were keeping the date, so counsel can pick.
So Mr. Riggins, give me the next Tuesday you're available.
I'm available the 17th. I'm sorry. Yes, I'm available on the 17th.
Okay.
I have
Heather,
11:30.
And is that with us, Heather?
The 17th no, wait a minute. The 17th is Judge Martin for
Okay.
exam.
All
Sorry.
right, so February 17th, 11:30 in the morning, Judge Martin. Okay, well, that gives you some more time to work on those medical records.
Thanks, Judge.
All right.
Probably get them by then.
And
Mr. Riggins, what we're going to talk about bond?
Yes, Your Honor.
All right, so let's make sure we're all on the same page with the current bond. 10,000, 10%, no third-party contact with Jasmine McCarter, and not to return to a Seminole Court address, GPS tether. That's what's in the file. I'm assuming that's all of it.
Yes, Your Honor.
Okay, go ahead, counsel.
Your Honor, I'd like to point out Ms. McCarter is on Zoom. She contacted my office. It is Ms. McCarter's intention not to go forward with any charges related to her. That would be the felonious assault and the domestic violence charge. I do know that she spoke with the prosecutor as well as the supervisor and indicated the same to them, that she had no intention of moving forward with the charges against her. I do, and I spoke with Mr. McCarter, let him know that the police officer resisting obstructing charge would continue forward. But as far as the case, if Ms. McCarter does not move forward, I do not believe that she believes, and again, that's why she's here, she does not believe that he's a threat or a danger to her. Your Honor, Mr. McCarter was employed or is employed. He is employed by Woodbridge Industries, and he is the father of 2 children. Mr. McCarter and Ms. McCarter have been together for, I believe, almost 18 years at this point. I don't think a cash bond as far as any officer is necessary. So we are therefore asking for a personal bond in this matter.
Mr. Leckie.
Your Honor, where I understand that Ms. McCarter may not want to go forward today, when I talked to her, when I authorized the report, she did. And we know how things change in domestic violence cases. One person's desire to go forward may change. That comes the next day. However, I do want to, make the court aware also that this is a habitual 4th offender. This is not his first time in the justice system. This is not his first time going through this. So he's aware. I mean, he's been charged with been convicted of a count of home invasion. Possession of a weapon by a felon is also resisting and obstructing a police officer. Those are mostly violent crimes. This is a violent individual, and we don't think that any bond should be amended, and definitely not a personal bond. And if he's to release, I would still ask for the tether to prevent any intimidation, where if this victim does choose to change her mind, that she be given the full opportunity to do so without the defendant's interference. Judge.
Mr. Riggins, anything else?
Yes, Your Honor. As to Mr. McCarter's record, I did look into his record. So his conviction for home invasion was almost 20 years ago, Your Honor, and he had a resisting obstructing 8 years ago. So, Your Honor, my client has not been in trouble in quite a long time. And again, as to the tether, that's why I asked Ms. McCarter to appear via Zoom, because she can address whether or not she feels any fear. I will disclose to the court, with my client's permission, he does have some mental health issues that he is currently getting treatment for. In addition, the day that this happened, Mr. McCarter was under the influence of alcohol. So again, I think that this night was a one-off. This was not a situation that is normal behavior for Mr. McCarter. As I see him today versus what I saw in the video, he is a totally different person. I don't think he's a danger to anybody at this point.
Okay. All right, so. All right, so as far as the 10,000, 10%, I think that's a reasonable bond, even if we don't have the charges with Ms. McCarter. I'm going to leave that as is. If Ms. McCarter wants me to change the no contact order, then I'm happy to hear from her on that, and I can delete that reference. But I don't think $1,000 to post is too onerous.
And Judge, if I may, can I bother the court one more moment?
And when you're done, Ms. McCarter is asking to speak.
All right. Bring her in.
She's in. Ms. McCarter, just unmute. Thank you.
Okay. Hi,
Ms.
how are you?
McCarter, good. Do you want me to change the no contact so that you can have contact with Mr. McCarter?
Yes, I would like the no contact changed.
And the no return to the address on Seminole, you want me to drop that as well?
I'd like that dropped as well too.
Gentlemen, anything to add?
Judge, just in that fact, I think if this is an alcohol incident, I think an alcohol tether would be appropriate then in place of a GPS tether.
We'll talk about that if he posts.
Yeah, again, I think that $1,000 does represent a hardship to my client, so I just ask you to reconsider the personal.
With respect, Mr. Riggins, I heard your arguments the first time around.
Then I have nothing further to add, Your Honor.
There's
Thank
no
you,
way that
gentlemen.
it could be reduced from $1,000?
Not by me, not today. Have a good day, folks.
Thank you, Judge.
Are you Javian Johnson?
Yes, sir.
You're charged with a second-degree felony of aggravated assault causing serious bodily injury. And this carries with it up to 20 years in prison. What are we going to do today?
He and I just visited this morning for the first time. I'm gonna ask the court, give me 2 or 3 weeks to review discovery with him and offer him, see if we can dispose of it.
Let me tell you this. I don't like what I read here. Let's see. Somebody enters the barbershop and you begin punching him in the face.
That's not.
Are you going to interrupt me? Or do you want to be held in contempt of court? I can put you in jail for interrupting the court. I know you're probably the kind of person that butts into everybody else's statements and interrupts and tries to control the situation, but it's not going to work. That's against the rules. Do you understand?
Yes, sir.
You should have learned that when you were a young child. I'm speaking. And the law says when I'm speaking, you can't interrupt the judge. You're going to have a fair opportunity. This lady has to take everything down. What reporter, if she can't do it because you interrupt, you go to jail. Is that clear?
Yes, sir.
It's going to read to you what the probable cause affidavit states.
May I interject something, Your Honor?
No. It was captured on video. It shows you. It shows a man entering the barber shop. And then says you could be heard saying this type of shit we do, roll up on niggas at the goddamn barber shop. It's on video and audio. I can't understand what, not in this, not on my watch is this foul mouth racial epitaph going to be allowed. Do you understand? Not on my watch. We're all created equal. Did you ever hear that? You didn't? We learned that early in school. We were all created equal. And what we make of it. But apparently you assaulted and the person has a fractured jaw, was transferred to Herman Memorial Hospital. But that is, and it's all on video, it states, and audio.
And Your Honor, he was actually the one video in it. He did not actually.
Who's he?
The defendant? Yes.
The co-defendant.
The co-defendant is the one who actually was
Said all
doing the
that?
punching, but it is all on
And
video.
did
They
this.
both went in together and
What did
yes.
Mr. Johnson do?
He essentially was encouraging him. They walked in the barber shop and he was videoing it as they're
Who's
going
doing all the
in.
foul mouth speaking?
That is Mr. Johnson.
Okay. You don't threaten people, and much less in a public place and use racial epithets. You should have learned better somewhere along the line. Anyway, it carries with it, it's a serious crime. It carries with it up to 20 years in prison. What are you asking for?
2 or 3 weeks to review discovery.
So we said 2 or 3 weeks. By the way, you were ordered to have no contact with the victim, nor anyone on your behalf. If I find out you do, your bond will be revoked and you'll sit in jail until this ends. Do you understand?
Yes, sir.
I don't know where the victim is, but you can't have any contact with the victim. Do you understand that?
Yes, sir.
Nor anyone on your behalf. I find out about it, the warrant will be issued so fast, you won't be able to get out of the country.
And Your Honor, if I could, I would request a GPS monitor if he doesn't already have one, just to, the victim actually suffered a broken jaw. I think it was $47,000 in medical bill. So I know the parents there were very upset and scared for the.
Whatever damages caused, the person who causes them will be ordered to pay. If you don't, you go to jail. It's the way we fix messes that are caused by irrational, irresponsible behavior. Okay, the request of the state is granted. You got 48 hours to get a GPS device and have it so we know where you are at all times.
Will point out, if I might, he's a high school student. He doesn't really have a family or any means to afford.
I'm sorry, he's treated as an adult. And we're all held to, as we're an adult, we're all held. If we make irresponsible acts, we have to pay prices for them. And that's all. If you didn't know that before, welcome to maturity and adulthood. You're responsible for your actions. It's the way it is. And you pay prices when you're irresponsible. Get a reset.
I need to reset and wait for my office.
Ashley, is it Otems?
I believe so. Yes, she'll give you the reset.
25 CR 1864.
Morning, Judge.
Folks, I got to step out of the studio for a few minutes. I'm just going to leave you with Judge Stevens. I'll be back shortly.
Charged, that's you, ma'am, Ashley Otems?
Yes, sir.
You're charged with the 2nd-degree felony of aggravated assault with a deadly weapon, which carries with it up to 20 years in prison. And who is the victim in this case? What relationship do you have to the victim?
He was my friend. He would bring me to.
You cannot by rule have any contact with him until this is over with. Nor anyone on your behalf. If I find out about it, you'll be put in jail until this ends. You understand? Because we get too much of that. People commit crimes, then they're going out trying to influence the victims. And that is severe wrongdoing. You're gonna have to deal with this, and everything is frozen. You don't go out and do backdoor speaking with victims. Victims cannot be communicated to by the wrongdoers, or else you get in trouble, or anyone on the wrongdoer's behalf. Okay, Mr. Dusler is your attorney. What do you do today?
I just asked it for a couple of weeks.
You got it?
Everything with her. But
Resetting. Stephen Salgado.
You can wait for me. I'll.
Was somebody cut with a knife?
Yes, sir.
What was their injuries?
Some stab wounds in the head.
He doesn't speak
I don't have all the, but it's stabbing.
Okay. You're shaking your head. Oh, the stab wounds were made up? He stabbed himself? Yeah, we'll deal with it later. Okay, who is this? Salgado?
Salgado, he does not speak English, but it's.
Another here. We're all not speaking English now. We got a rash of that all of a sudden.
His sister's here, but Your Honor.
You got it.
Okay. Thank you. She's a licensed translator, and that's what we need here.
If you're a warm dog.
Please raise your right hand and please tell us your full name for the record.
Jeanette Vallecillo, Balleciillo.
And thank you for being here. Do you solemnly swear or affirm you will truly and accurately translate from Spanish to English, English to Spanish, which is the language that the defendant, Stephen Salgado, speaks Spanish, and you will translate his answers from Spanish into English, so all of us in the court reporter can hear, and our English in questions for him into Spanish, the language he speaks, his native tongue. Will you do that accurately and correctly? So help you God.
Yes, Your Honor.
Thank you. You are Stephen Salgado?
Yes, I'm a Stephen Salgado.
You are charged with the third-degree felony of operating a motor vehicle while intoxicated. Do you understand?
Yes.
Furthermore, the indictment here states that you have 2 or more prior DWI convictions. This third one makes a third-degree felony. You are looking, if convicted, no less than 2 nor more than 2 years imprisonment, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
All right, Mr. Dusler here is your attorney. Correct?
Yes.
Go ahead.
Judge, we're gonna ask for a couple of weeks on him as well. We think we have an acceptable offer that's gonna include safety as well. He needs to check with his work and see how that's gonna affect it. I think we're gonna get it resolved in a couple of weeks.
What happened on this October 19th, 2023 case? That was out of County Court of Law 2 of Jefferson County.
October 19th, 2023.
Yes, sir.
You received 30 days jail time.
Just flat 30 days?
Yes, sir.
Okay. Because it commits this on April 20th, which is going on almost 2 years.
Yes, sir. The blood test on this, as I know you like to know, is 0.168.
Twice the legal limit.
And that's all factored in as to why I feel like he just needs, I'm willing to give him probation as long as he goes to safety. I want to address the problem.
Is your address, do you still live at 3349 5th Street in Port Arthur?
Yes, that's.
Okay. You cannot operate a motor vehicle unless you have an interlock device. If you do, you are in trouble. Your bond could be revoked and you could be placed in jail until we get this finalized. Do you understand?
Yes.
Follow your lawyer's advice.
Sigan los consejos de su abogado, lo que le diga su abogado. Lo que sigan los consejos que le va a dar su abogado. Okay?
Get every setting. Thank you. DeMarcus Roy.
Yes, Your Honor. He's custody, but
Here or?
No, he's in Hardin.
Why did he prefer going to Hardin County?
I don't think he chose.
Oh, he didn't choose. What do you want to do? Reset? What's, how are we gonna get it?
I will go.
Pick him up?
No,
Oh,
but I will go.
I thought you were a full service attorney. And
Unfortunately, I had many times.
okay, how much, what do you want to do today? Reset?
Just
The win.
reset 2 weeks.
Three? Done.
Thank you.
Robert Chason.
Take care of it. I'm gonna if you need anything.
You're not here. Robert Chason is called 25 CR 1845. There was no answer here in the courtroom. I asked the bailiff to please call into the hall for Robert Chason. No answer in the courtroom.
Go ahead and get your bond revoked.
Wouldn't be the first one this morning.
No, it won't be the last. Yeah, that's it. Well, maybe the last this morning.
Yes. Wow.
God bless you. Judge, your sign says splash zone.
No response to the name called in the courtroom. No response to the defendant's name, Robert E. Chason here. Into the hall by the bailiff. Defendant has failed to appear. A warrant shall be issued for his arrest. His bond, which was
$20,000 on his face.
sorry, he does have two cases. 1845 assault on a peace officer and 25 CR 1846, the third degree felony of harassment of a public servant. They were how much on each? Okay, and each of those all hereby doubled. $40,000 on each case is now ordered as the defendant's bond. Plus, he must have a GPS device on him at all times, so we know where he is when he's not when he's supposed to be. A warrant will be issued for him. Looks like that's all we have. There's nothing else. Nobody has anything else here, and so it looks like we're going to just move on with anything else other than anything Mr. Crenshaw. Okay, Melvin Espinal.
But I'm gonna swear fingerprints on me.
I think I'm pronouncing his name correctly. Espinal.
Yes.
Espinal. I'm doing better. I have the experts with us today, so I'm trying to do my best.
Kind of pronounce it probation, Espinal.
Oh, yeah, 3 syllables versus 2.
Mr. Boyd, would you please print a discovery? Yeah.
Yes. Okay. Mr. Espinal.
Right over here, sir, you're gonna do.
And we'll need.
Raise your right hand.
He speaks English.
Oh, he speaks English, yes, it's Mr. Rodriguez that does not. He's next.
The right number. One more time, please. Same one. Good. Yeah. You go stand in contact.
All right.
You're Mr. Espinal?
Yes, sir.
Is that you? Okay, Melvin Javier Espinal. Espinal is in Spanish. Espinal. I know, but what does that translate to in English?
Probation.
Like spinal.
I concur. Correct.
Oh, yeah, you two work together as a team. Y'all do a lot of damage that way. You two lawyers.
Final. Yes.
Oh, in the back?
It sounds.
Oh,
Yeah, close to-
Oh, it's a spine, spinal. Okay. But it's close to Espanol.
There you go.
Which was kind of had me
That is
a little off balance. All right, Espanol. 23 CR 440 is called. Mr. Espinal is present with his attorney, Mr. Crenshaw, the state's attorney. Sir, as you know, you were charged with the third degree felony of operating a motor vehicle while intoxicated. What bothers me is this is the 6th one.
believe there's been 5 judges.
I've got 5 prior convictions of DWIs and now this one. That, they taught me it in according to Groves School.
You've got a
5 plus
figure,
1
yeah,
equals
got
6.
that, yeah.
Is this your 6th one?
Five.
You have a conviction in 2008 from Harris County. A conviction in 2009 from Harris County, a conviction in 2010 from Harris District Court in Harris County, 2018 in District Court of Brazoria County, and in a different cause number, 239th District Court, another conviction out of Brazoria County. All 5 of those for DWIs, operating motor vehicles while intoxicated, and now this one. That's
I think you resolved 2 in 2009 at the same time, Judge, so.
But it's 6 separate offenses, is what I'm saying. Is there a problem here?
There is, Judge.
What are we gonna do?
He's had some pretty substantial treatment while this case has been pending. We were hoping that would make enough of an impression to get probation, but it was not, and so we're here for a penitentiary.
All right. Does he waive formal reading of this indictment? Can we proceed in summary?
He does, Your Honor.
In summary, sir, this indictment in paragraph 1 alleges that on or about September 24th, 2022, God, that took a long time to get here.
Well, I think the
In
arrest
Jan-
was either during COVID or right after COVID, and
I thought COVID was 2021. In September 24th, 2022, in Jefferson County, Texas, you operated a motor vehicle in a public place while you were intoxicated. Do you understand what you're charged with in paragraph 1? That's bad enough, but paragraph 2 goes on to allege 5 prior convictions. We're gonna only do a couple of them, okay? Among other convictions, this alleges that in paragraph 2, that on February 26, 2008, in cause number 1491795 out of County Criminal Court at Law number 13 of Harris County, you were convicted of an offense relating to the operating of a motor vehicle while intoxicated. Well, that really doesn't work, does it? That's not worded right. You have to be convicted of an offense of operating a motor vehicle while intoxicated. This says relating to, I mean, there could be that's not worded right.
can we abandon the word related, Judge? Yeah. We'll agree to that.
Well, relating to we'll take out, so convicted of an offense operating of a motor vehicle while intoxicated. How's that?
No objection.
In fact, I'm adding of here. You understand what this states, sir?
Yes, sir.
And then also the second allegation in paragraph 2 of the 5 allegations states that on April 1st, 2009, in 1563111 in the County Criminal Court of Law number 13 of Harris County, you were convicted of an offense relating to the operating of a motor vehicle while intoxicated. And I guess just add of, take relating to the out and correct it that way. Any objection to that?
No.
It's done. Stay.
Okay.
So do you understand what you're charged with in these 2 paragraphs?
Yes, sir.
This constitutes a 3rd-degree felony, which means you are facing no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Okay.
This is various. We have to have so many prostheses just to do this, because these new pads operate completely differently. If you touch anything, it dismisses, it erases it. So you're facing a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case. Remind me, you've got to sign this, Corey, at the bottom of this page, that you would be pleading guilty, sentenced to 3 years in prison. Is that your understanding of the agreement? You have to speak out.
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to paragraphs 1 and 2 of this indictment charging you with this third-degree felony of operating a motor vehicle in a public place while intoxicated? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily on your own free will and because you are guilty?
Yes, sir.
Okay, I'll show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents true and correct?
Yes.
State's Exhibit 1 tendered and tagged.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. Here you go. You understand what you're charged with? You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to be apparent, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Wait, Your Honor.
I am going to follow this agreement with nothing further to add and find, sir, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 here admitted to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt based upon your plea and this representation on State's Exhibit 1. And I'm following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 3 years. As you have pleaded, correct me if I'm wrong, guilty to paragraph 1 and true to paragraph 2, which alleges the prior WI convictions. Is all of that accurate and true?
Yes, sir.
Anything else?
Nothing.
Okay, is he taken into custody immediately?
Well, I'm assuming that's the only option. Is there another option?
Sometimes there is, it depends on the circumstances. You know, if they're cooperating with, you know what I mean? I don't know if he is or not.
Yeah, you want to sell it tomorrow?
He's asking to turn himself into Mark.
I'm gonna, we
You can.
done.
I just have to deal with my car and interlock.
Yeah, you signed the interlock order yesterday, Judge, so he's gonna get that interlock removed. But he won't
Yeah,
arrive.
yeah, because that's gonna run up a bill.
Okay, and he'll surrender to the county jail tomorrow?
That's the other state, that's good. Under these circumstances.
Okay, great. Thank you, Judge. Is there a time tomorrow about 6 p.m.? Is that okay?
On before 12 or 2, what is it, 2 or? There's something about the afternoon.
I'm not sure. I know.
On before 2 o'clock.
2 o'clock.
I know for probation it's before 6.
All right, this is a drunk driving OWI. Does she stand mute and wait formal reading? All right, I'm entering a not guilty plea for, is this a first offense?
Yes, Your Honor.
Allegedly, what was the,
I believe it was the IBAC. I would say 2-1. Don't quote me on that, but I think that was
she is 20, just turned 24, right?
correct.
All right, I'm entering a not guilty plea. I'm signing your order for discovery. We'll set a pretrial date. I'm gonna give you a personal bond of $1,000. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm gonna order the man to not purchase, possess, or consume alcohol or illegal drugs, okay? I do want you going to AANA at least 1 time per week. You have to go in person. We're gonna hand you a form. Every time you go, you have to have the form signed. And every time you come to court, you have to bring that form with you. Do you understand all that? All right. So what do you have for me, Heather?
It'll be February 18th at 9:30.
Is that good with you?
Thank you.
February 18th, you said at what time?
9:30.
9:30. Okay, that's what we'll do.
Thank you so much.
And you can, here, I'm gonna give her the form. You can just bear with me once. I'm gonna give her a copy of the bond sheet. And, whoa. Mutilated copy of the bond sheet. Yes. There you go, ma'am. You can approach and we'll hand you that. And,
It was a discovery order as well.
I signed that.
Thank you.
I did sign that, and you can go down the hall and they'll give you a copy of it, okay?
Thank you so much.
One other thing, you just double check something. Yeah, we're all set.
Thank you so much. Have a good day.
Have a good day. Thanks. All right, Audrey and Cusino, 25F245225. All right, good morning, Mr. Osmond.
Good morning, Your Honor. Jeff Osmond on behalf of Audrey Kuzma.
Your name, ma'am?
Audrey Kuzma?
All right, so your client pled guilty to operating while visibly impaired. She was referred for screening and assessment. Any material additions, corrections, or deletions?
No, Your Honor, and I would indicate to the court that she does have her AA sheet here, she's been attending.
Okay, and you've seen that?
Yes,
She's
sir.
been going at least once per week?
Yes, sir.
Okay. What else would you like to say?
Judge, I've spoken to her at great length about this incident. She takes it very seriously. She is going to do everything she can. She has this is totally out of character for her. No prior history with law enforcement or anything of that nature. Comes from a good family. And I'm sure we won't see her again back here.
All right, ma'am, is there anything you would like to say?
I would just like to say I'm very sorry and I fully learned my lesson from this.
Okay. All right, good enough. I don't usually only go 8 months, but she scored in category 1 on everything, so I'll go along with that. 8 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You do have to report as directed, no alcohol, no illegal drugs, no marijuana. You can't go to any place that sells or dispenses alcohol. They're recommending bi-weekly testing. I'll go along with that, but I'll only make you test bi-weekly for 3 months. If you're clean, then I'll make it monthly, okay? Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. Attend a level 2 alcohol education program and the Victims Impact Panel. That's one night put on by Mothers Against Drunk Drivers. 4 days jail credit, 1 serve 3. I'll let you serve those by way of community service. So 3 days community service, that's 24 hours. And I'm going to give you until March the 25th to complete that. So you got about 7 weeks, okay? So 24 hours community service. You may be eligible for early discharge. You're going to pay fines of $300, costs of $300, $75 victims' rights fee, $50 justice assessment, 7 1/4 probation fees. $160 for a total of $885. You have a screening fee of $60 for $945 plus your cost of recovery. Everything included amounts to $1,170. Again, if there are no violations, you can apply for early discharge in 4 months. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand all that?
Yes, I understand.
Judge, I'm sorry, could I ask for, she had asked me earlier, a family that she grew up with is going to Mexico from the 20th to the 26th and invited her to come with them if she could have permission to do that.
Yeah, you know, these states, these countries, I don't know who lets who in. I'll just say she can leave the state. I'm not saying she can go to Mexico. You need to double check, make sure there's no problems. I'm sure there's not.
Yeah,
But like Canada, you can't go into Canada.
Canada would be an issue, you're right.
You can leave the state between February the 20 Is that-
To the 26th.
I'll make it the 27th in case the flight gets delayed. How's that? Okay, and can she pay all this today or does she need time?
I can pay all this today.
All right, I wish you well, and then you'll meet with probation, okay? Best of luck to you, ma'am. Thank you.
Thank you.
Thanks, Mr. Osmond.
Yes, Your Honor.
Liliana Marie Vanderhoof, 26W841159 A and B. Your name? Charged with driving on a suspended, you have the right to a lawyer. If you want one, I'll give you one. I can't hear you.
No.
You waive your right to a lawyer?
Yes.
On January 4 of 26, it is alleged that you did operate a motor vehicle with a suspended license on I-75 near West and Woodhaven at 1:27 in the morning. That is a misdemeanor. It is punishable by up to 500 fines, 93 days jail costs, or all those in 2 points. Do you understand that?
Yes.
Did you sign the advice of rights and read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that? You have the right to a lawyer, as I said. You still wish to waive your right to a lawyer?
Yes.
I'm an enter a not guilty plea, $500 personal bond. You don't have to post any money. Here are your bond conditions. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. So those are your bond conditions. You'll owe the people of Woodhaven $500 if you violate any of those. And I'm entering a plea of denial on the speeding. You understand that?
Yes.
So you're gonna go talk to the prosecutor and then you'll come back in here, okay? Thank you. Lori Hinkle.
Yes, sir.
Lori Gay Hinkle, 26W841130A and B. Your name?
Lori Gainville.
You smell of alcohol, I'm told, Ms. Hinkle. Are you
I
drunk?
was drinking last night.
Are you drunk?
No.
We're gonna give you a PBT, okay? You're gonna, my court officer is going to administer a PBT to you.
I
So,
was drinking too.
ma'am,
Go ahead and see the hallway.
we're gonna administer a PBT to you.
Go ahead and see the hallway.
And you'll go out and, so that goes to the prosecutor. That's the PBT. People against levity.
Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live, where apparently people are showing up to court smelling of alcohol. You gotta love it. Let's continue with Judge McNally for a bit.
This is the time and date sentencing.
Your name, sir?
Read levity.
All right, I want to make sure, first of all, have you had a chance to review, he pled, by the way, to this, under height at a window peeping.
That's correct.
And, he was to go to AANA twice a week. Have you
Yeah.
seen that for him?
10 visits.
He's been doing that? Okay,
Yeah.
good.
Should I submit this to your clerk for copy?
No, that's all right. I trust you. He's gonna need to keep that, okay?
He's been doing really well on that, Judge.
Good.
Very seriously. Whenever you're ready, I can address the PSI.
Yeah, have you had a chance to review the report? Now,
We did, we looked it over this morning. I went over with my client. The only real issue is that we had, seems to me like outpatient counseling is a bit extreme. If he's testing twice a week, he's been clean, he's been following the court's recommendation and order. As far as AA goes, maybe if the court was inclined to entertain that particular element, that if he tested positive, maybe that it could trigger outpatient. Because he expressed to me this
Well,
morning.
I mean, I think their concern is, he had THC in his system. He acknowledged he was using marijuana and he had 10 beers and now he's going in the backyard of somebody's house and window peeping. I mean, I don't think it's that extreme, but I get it. Go ahead. I'm sorry. I didn't mean to interrupt.
No, and I think that's a very valid point, and I think that's something that he expressed to me this morning was that, I think he's relieved that this ended where it did, and it didn't result in something more extreme. I mean, people get shot for stuff like that. And that was something that he expressed to me was that,
you know, in the grand scheme of things, the severity of it was probably as minimal as it could be. But Judge, yes, I would say that, you know, given the fact that you know, going to 2 AA sessions per week and had, you know, weekly or bi-weekly testing, whatever the court would order on that. If he did test positive and he's quit smoking marijuana for the most part, I think. If he tested positive for alcohol or drugs, any illegal drugs at any point in time, then at that point in time, couldn't that trigger an outpatient program?
Okay. That's your argument.
Yes.
I got it. Anything else? Either one of you?
Read you everything?
I just want to say that was a dumb mistake and I'm glad it turned out the way it did. Could have been a lot worse.
And you went over and got fingerprinted, right?
Yeah, I did, right after the last court date.
By the way, I just need to ask, is there a Tyler or Brooklyn Wilson here?
Drop this off.
All right, I'm gonna take this under the Vehicle Training Act. As agreed upon, that's what you guys agreed upon, I'll do that. 15 months probation, you cannot leave the state without the consent of the court, you cannot violate any law or ordinance. You change your address, place of employment, or home telephone number, you must notify probation, you have to report as directed, no alcohol, no marijuana, no illegal controlled substances, you're not to purchase, possess, or consume any one of those, you're just kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing PBTs bi-weekly for 4 months. If you're clean, I'll then make it monthly. No contact with Brooklyn Wilson or her family members. No contact with her or her family members. You're not to enter the property or go near the property address of 19116 Hyde Park Court in the city of Woodhaven. I'm gonna order 4 days jail. I'm gonna let you serve those as follows. 3 days on the court work program. There's a $35 a day charge for that for a total of $105. And 1 day or 8 hours of community service, which you have to complete in this case by March the 20th. I am gonna order that you continue attending AANA twice a week in person until you're in outpatient treatment. I'm gonna order outpatient treatment as well. We're to attend that and complete that. Fines. So you understand the sentence so far?
Yes.
Fines are 100, costs are 200, 75 victims' right fee, $50 justice assessment, 4.25, screening fee 60 for 485. Probation fees are 300 for 785 plus your court work program fees. Your total's 890. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford them. You understand that?
Yes.
All right, that's what I'm gonna do. Does he have all of this to pay?
I'm sure he probably would need some time to make payments, Bill.
How much do you have today?
I didn't want to pay it all time sheet.
I didn't ask you that. How much do you have to pay?
I can pay 100. I can pay 100.
$100 now, 75 a week, you can do that, right?
Yeah.
75 per week, I'll give you a little bit of leeway. Or give you a little bit of a head start, so to speak. So I won't have you pay this until February the 27th, and you'll meet with probation. And if you ever don't have the money, you call the clerk and on Zoom, I'll give you an extension, okay? Honor before the duty. Good luck. Thanks, counsel. Lori gave.
Good morning once again, everybody. TCF Live. Good to have you here. Lots of courts just getting their days started. But I'm going to hang with McNally for a little bit because I want to see if the person comes back that they did the PBT for.
You're drunk.
Well, there you go.
Well, sir.
You said no, sir. What's your name? Tell me your name.
My name's Lori Gainful.
You got a 0.166 on the PBT.
I was drinking till 4:01 and I didn't, Hell, that I couldn't believe that was.
You're still drunk.
No, it was.
Man, we got a 0.166. Who drove here?
My friend.
Is this the guy here? Did he drive?
Sir Ronald Raymond Hamilton, the left president.
Slow down.
President.
What?
of the United States.
Hang on a second. Who?
The 11th president to the United States president.
What's his name?
Sir Ronald Raymond Hamilton. The president to the president.
You ready?
Yeah.
The president of the United States?
Yes,
The president right now?
yes, sir.
He's shaking his head no. Why is he shaking his head no? If he's not the president, why?
No, he's not president. He's the 11th president.
11th cousin. He's shaking his head no. That he's not the 11th cousin. And honestly, I don't care if he's the brother of the president. It's not gonna help you, so I don't need to hear this. What I do want you to know, if you show up for court again drunk, we're gonna have a big problem. I'm gonna reschedule your case. Sir, you cannot let her drive. Do you understand?
Thank you, Trish.
Well, you know, you gotta,
Pledge allegiance.
I'm sorry,
Pledge allegiance.
pledge allegiance? Is that what you said?
Yes. I'm unjustified.
Just relax. Heather, give me another date, will you please? I should probably have you locked up until you go down. Give me another date.
We could do February 18th at 9:45.
Come on up here, sir. What is your name?
My name is Ron Hamilton.
Did you drive her here?
Yes, I did. I smelled alcohol when she got up.
You live with her?
She stayed with me last night. She asked me 2 days ago if I'd come with her. I told her yeah. She left my house when she got here.
Is she gonna have access to a motor vehicle?
No. Not have anything.
Do you own a motor vehicle, ma'am?
That's what
Does she?
a 2010 Ford Focus.
She owns it.
Light gray.
Well, hang on a second. You just told me she didn't have access. If she owns a motor vehicle, how does she not have access to the vehicle?
I'm a woman. I picked him last night.
Go down the hall, get your new date. It's going to be February 18th
February 18th.
at 9:45 in the morning.
You think 45 an hour, no alcohol.
Don't show up drunk. Don't show up after consuming alcohol.
Okay, sir.
We understand?
Okay.
Sure. I'm gonna let her go. I'm gonna trust you're not gonna give her those keys.
Thank you. I'm trying to get her into a treatment center for alcoholism.
All right, let's not have any further discussions here, okay?
Okay.
That's what I'm gonna do. Do not drive. Do you understand?
Yes,
Do not drive. You understand?
yes,
Sir.
Go down the hall. They'll give you a notice. Thank you.
Ms. Knuckles, good morning. Ms. Knuckles, you're here because you've got 2 allegations against you, ma'am. You've been accused of 1 count of grand theft in a new charge, and then you have a second charge of violation of state probation, ma'am. I'm going to go ahead and address your bond status on the grand theft first. Let me see if the attorneys have any additional information. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
So Ms. Knuckles, you're entitled to a bond on the grand theft. I'm gonna set your bond at $10,000 cash or surety with the condition of no contact with the alleged victim. Ms. Knuckles, the problem is that you have a no bond violation of probation warrant signed by the circuit judge, Judge Garcia. So even though you've got a bond in the new case, there's no point in trying to make it because you've got no bond in the VOP. In the VOP case, I'm going to go ahead and arraign you because I want to get you a lawyer appointed today if that's what you're asking for. In the violation of probation charge, would you like to have an attorney appointed to represent you?
Yes, sir.
Did you say yes?
Yes, yes.
Okay, I'm going to appoint the public defender's office to represent you in the VOP case. Listen to Mr. McDaniel, and we'll see if you have any questions in just a moment.
Your Honor, we're going to enter plea of not guilty as said on the March 3rd court docket, and attorney had talked to her on that day.
And Mr. Mitchell, anything from the state?
No, Your Honor.
So Ms. Knuckles, an attorney will see you on or before the court date, ma'am, in March. And you've got no bond in the VOP case. Do you have any questions, Ms. Knuckles?
I have no clue what this is about. I feel like I have been totally,
Okay.
I'm shocked.
The allegation is that you sold a piece of property and don't respond to this. I'm just telling you what you're accused of. The allegation is you sold a piece of property and there was some kind of pump on the property on some kind of spring, and that the paperwork clearly says that went with the property. And then weeks later, after the sale, allegedly, you removed that pump valued at several $100s. That's what you're accused of. That's the basis for the grand theft, and there's supposedly some witnesses that saw this. So that's what it's about. Don't comment on it. I'm just trying to make sure you know what you're accused of. Do you have any questions?
All right, I'll let you down.
We have Tina Taylor next.
No, you do Richard Smith next. And
Sure, Richard Smith.
Taylor.
Mr. Smith, good morning. Mr. Smith, you're here because you have a holdout of Calhoun County. Mr. Smith, I took a look at the warrant this morning. It has no bond on it. It's several felony charges down there. Mr. Smith, what that means is you're going to be held for Calhoun County. You'll get picked up by them the next day or two. When you get down there, you'll go to another first appearance, Mr. Smith, and that judge will address whether or not you're entitled to a bond. But right now, there's no bond on the warrant. Mr. Smith, do you have any questions?
Oh,
Know what he's trying to say to you, Wilson.
hey, Mr. Mercer, I got a
Yes,
year
sir.
county probation for all them charges. I bonded out of here and went to Calhoun and signed a year county probation for all them charges. They got dropped down to a misdemeanor. I never caught a new charge. All I caught was a failure to appear here in Jackson County. And I signed 5 years probation in Chrome yesterday. I'm just trying to figure out what this is going on, like what's up with this, because I
Okay,
never caught a new charge.
Let me go look at the warrants because these are recent warrants. Let me see when these supposedly happened. I looked in the warrant system this morning because it's not in their regular system. It's only in our warrant system.
Your Honor, I will tell you that he did enter a plea yesterday. So what he's saying about entering into probation with Chrome is true. I don't know if this was already pending charges that he had simultaneously.
Yeah,
This warrant was signed. This warrant was signed yesterday at 11:09 a.m. supposedly regarding an incident on December 15th. December 15th.
I was in jail.
So there's a ag assault on December 15th. The second charge is ag assault. The third charge is false imprisonment. And then there's a battery, all allegedly occurring on December 15th. So
I was in
what I
jail
can
on
do, it's
December
not,
15th.
it's not our county. Well, that doesn't mean I don't know anything about it. It could have been something that supposedly happened at the jail. I have no idea. I'm going to ask Mr. McDaniel to notify his counterpart in Calhoun County, Miss Parrish. And if there's an issue, this is something you've already resolved. Obviously, they're going to be on it this morning. Okay.
Yes, sir. Appreciate you.
Yes, sir. Have a good day. After Mr.
Tim, thank you for gifting 5 memberships. Very much appreciate that. All of you in the community, very much appreciate all of you. Thanks so much.
Mr. Come on up, Mr. Stanford. Corporal, this is similar to a federal warrant or an immigration only hold when there's no local charges. I don't have any authority or jurisdiction over him at all. I can't first appear him. Mr. Standiford, you have a hold, something to do with the U.S. Navy, some kind of being AWOL allegation, but it's not something you have anything in state court on. Mr. Standiford, do you have any questions?
No, sir.
All right, wish you the best, sir. So Corporal, it'd be just like a U.S. Marshal's hold with no local charges. There's no point in putting him on the first appearance docket.
Yes, sir. We figured, but we weren't 100% sure.
No problem. I've never seen one of those before, so thank you.
Yes, sir. No problem.
We had Fiona Best, Mr. McDaniel.
No. Tina, I'm sorry. Oh, Fiona Best is, she is out of the, she's at the hospital, Your Honor. She's,
Okay.
yeah.
So Ms. Best has a medical situation and she's got a violation of state probation with no bond and a holdout of Bay County. So Corporal, just keep us up to date on her situation when y'all know more, please.
Yes, sir.
We appreciate it.
I'm gonna go ahead and enter a plea for, I talked to her, so out here and plea of not guilty and ask to settle on the March 5th for now, Your Honor. And, we'll go from there, see what happens with the hospital stay.
Okay.
She
that'll
was unconscious when she left, so I don't know what's gonna.
If they admit her at the hospital, Corporal, considering that you got 2 counties involved, so probably the thing to do is y'all to contact Judge Garcia. If there's a request for a medical furlough, but Judge Garcia is going to have to communicate, knowing her, she would do the same thing I would do. She'd communicate with the Bay County authorities before granting that. But she don't do anything until we see what happens with the intake stage at the hospital.
Yes, sir.
All right, and that brings us to Tina Taylor. Ms. Taylor, good morning. Ms. Taylor, you're here, ma'am, for a sentencing in Jackson County case 25-556 CT. Ms. Taylor, you entered a plea to the charge of driving while license suspended or revoked. Your sentencing was set for yesterday at 8:45. Judge Garcia was covering first appearance yesterday, and my understanding is she did first appearances and you still weren't here. She issued a warrant, and at some point, a little while after that, you showed up downstairs with 2 small children, is what I was told, for a sentencing, which is inappropriate. But you were taken into custody and you're back this morning. So, Mr. McDaniel, I know that I haven't heard anything since this morning, and I don't know if Mr. Mitchell has. Have you had a chance to look at any of her documentation that she was supposed to bring with her to court yesterday, Mr. McDaniel?
So I don't know anything about this case. I'm not a court tour, but she does have her schedule here when she clocked in and out of her work. And I'm not sure what y'all want to know about it, but she does have that with her.
All right. So Ms. Best, I'm sorry, Ms. Taylor, do you want me, Mr. McDaniel, to represent you for sentencing purposes this morning?
Yes, sir.
Okay. So Mr. McDaniel, I want to make sure if you're involved, we do it appropriately and get you your fee if you're entitled to one. I think you are. So Mr. McDaniel, the question, I sent you a text this morning. The question, she was supposed to show up at sentencing with proof that she is getting off work on November the.
This is for 3 months, and that was at 10 a.m. to 2:30.
November the 9th, she got a ticket at approximately 2:40 a.m. She said she was just getting off work. I set a sentencing date because Mr. Mitchell was asking for a jail sentence, but the state and the court wanted to know if that was true or not.
That was
November the
that's the
9th at 2:30 a.m.
So we need to go back. I don't see the date on here, but he did it.
Yes, December 21st. So it was in November. What day was that on? A weekday?
November the 9th. You're asking what day of the week?
Yeah, let me look at it and see. This is gonna be here. See, November 9th. Would have been a Sunday.
Nothing there. Sunday. No, that's not it. This I just saw it. Can I see? Six 5 to 2:30 a.m. I got off at 2:31.
So she looks like she got off work at 2:30 or clocked out at 2:31 a.m.
On November 9th?
Yes.
Okay. So Miss Ms. Taylor, the other question I had is, why would you bring two children with you to a sentencing yesterday, knowing that you know
They
there
were
was a possibility of you
leaving.
going to jail?
They were leaving, Your Honor. They was dropping me off. They was
I
going
don't
with my
understand.
niece.
Why
That
did they
was
come to the
my
office
ride.
with you? Why did they come into the office with you then?
The bailiff told him to. He told us all to come.
Okay,
They was
ma'am, so tell me what happened. You showed up here yesterday morning after school time started. Why wasn't the older child in school?
my oldest child. She is she got her a GED. That was my niece. And then my 7-year-old, I was taking her. She said her stomach was hurting, so I was gonna take her, have her go with her cousin to the doctor. And my 4-year-old isn't in daycare anymore, so they
Okay,
were together.
So you get here and you come into the probation office or the judge's office, the courthouse,
No,
right?
I went upstairs, sir, first. I went to upstairs, and
Right.
then I went to the courtroom. I didn't see anyone in there, and then I saw the bailiff, and he asked me where I needed to be and what it was for. And I told him my
Okay.
name, and he told me that they had already called me. And then
Right.
that's when he told me to sit down, and then he went and spoke to Miss Garcia, and then he told me to hold on. And then he came out, and then we went downstairs together with the bailiff, sir. He told us, he said, "Are they
Okay,
with you?"
so
I said, "Yes."
back to my question then, why would the children come in court with you if they were just dropping you off?
Because she wanted to make sure I was there. I wanted to make sure, like, they'll be okay. I wanted to give her my phone, and then once I got in court, they were gonna leave.
Okay, so Mr. Mitchell, I watched the video again to make sure I remembered everything. At that point, the state was asking for 30 days in jail. She had a recent, as in maybe July, driving license suspended or revoked in another county. So I thought the offer was very reasonable, but after hearing her version and her employment history and her taking care of her children and so forth, there was some concern the state had and the judge had, frankly, about not necessarily wanting her to lose her job. So we came up with this solution to see if she really was leaving work like she claimed she was. And apparently she was, based on what Mr. McDaniel was seeing this morning. So has any of this changed your recommendation, Mr. Mitchell?
Based on the information that's been provided to both the state and the court, our recommended disposition would be changing it to 1129 probation with a $400 fine, standard conditions that follow this type of charge.
Okay, thank you. Mr. McDaniel, anything else on behalf of Ms. Taylor?
No, Your Honor.
Ms. Taylor, I think Mr. Mitchell's reasoning is well sounded. It seems like he's being logical. He's trying to help you, and I appreciate that. I'm going to go with his recommended disposition instead of doing the 30 days in jail that they were originally asking for. Having gotten more information, I'm going to sentence you to 11 months and 29 days probation. You'll have the standard conditions of probation, plus you'll have the standard court costs and fines of $400. Ms. Taylor, you will also have the standard condition that you obtain a valid driver's license if one is reasonably available to you, and that you not drive without a license. So here's what's going to happen, ma'am. Ms. Taylor, the jail's going to let you use the phone to contact anybody you wish for transportation, and then they'll let you get dressed in your regular clothes. They'll bring you to the courthouse. The probation office is at the courthouse. That's why they'll bring you here. When you get here, you'll meet with the probation officer, Mr. Goodson or Mr. Ham will go over the probation with you. They'll answer any questions you have. They'll give you a copy of the rules in writing, and then you'll be free to leave. Ms. Taylor, if you call friends or family, you can tell them you can be picked up at the courthouse in probably 30 to 45 minutes. Ms. Taylor, do you have any questions?
No, sir. Yes, I do.
Okay.
Since it is so hard for me to get my license, is there any way I could apply for like a hardship? Because I looked into it and it says I would have to have a court order.
There's no such thing as me. There's no judge that can order DHS&B to give you a court order. That's impossible. What can happen is Mr. Goodson can take a look at your driving record, and he's a probation officer. He's kind of our resident expert on driver's license. He's very knowledgeable in that area. But he could probably take a look at your driving record and tell you whether or not you may qualify for a work permit and what you would have to do. You'll be expected to get a driver's license if one is reasonably available to you. So some people got to pay a ticket and get a license, and that's all there is to it. Some people, it's much more complicated than that. And if you can't get one, you can't. But you'll be expected to at least look into it and make an effort. So Mr. Goodson will be the one to ask that question, okay?
Yes,
Your
sir.
Honor.
I just heard her
if we
say
want-
about I'll let her know. I heard her say about a high cost. I mean, usually if it's because of fines and things like that, they will work out a the clerk's offices in the state will work out payment plans. And that way you can get your license as long as you continue to make those payments as you agreed to with them, then you'll keep your license if it's financial.
I think there were 5 unpaid tickets from Washington County. When I looked, when she pled, that's what was on the video. Mr. Mitchell?
I guess, I don't know if it makes a difference, but I guess for purposes of the record and maybe to help her out, we can put on the disposition letter that the state has no objection to a work permit or a hardship license. It may help her, it may not, but can't hurt.
And the state's input on the civil matter I don't think it carries.
Yeah.
It's like my input. She's got to comply with DHS&V. They're their own
entity.
rulemaking. She's either got to pay the tickets or enroll in a payment plan, like Mr. McDaniel said, and then she may qualify, I think. In Jackson County or another county. So our clerk, Ms. Williams, says you've got a criminal court costs and fines in Washington County that's going to have to be paid too. Something that was driving to spend a license over there.
I think that's what.
So you'll get to use the phone in just a few minutes, ma'am, okay?
Okay.
Thank you. Mr. McDaniel, anything else from the public defender's office this morning?
No, Your Honor.
And Corporal, anything else from the jail?
No, Your Honor.
We have a lot of people that are supposed to be here but aren't. But we ain't too proud to beg, so we'll just get started. All right, good morning, everybody. You're here for an arraignment. The arraignment is the process where the judge tells you what you're charged with and asks you how you wish to plead to the charge. When I call your name, I want you to come right up here to the podium, and then we will discuss your case. We'll start with Daniel Taylor. First person to check in. This is file number 252534. ST, that stands for statute traffic. There's some other numbers on. Oh, Laura, I'm out of register of actions. I knew that late yesterday and I forgot to tell you. Mr. Taylor, you're charged with operating without a valid operator's license. That's a very common charge, sometimes called no ops. It's a misdemeanor punishable by up to 90 days in jail and a fine of up to $100. Carries 2 points. You were supposed to be here on December 11th, and you didn't come. You were supposed to be here on January 8th. You came the next day, and they reset the matter for today. Then you were supposed to be here on the 22nd. That's the day the pipes broke and the courthouse flooded. So they reset it for today. You're also charged with no proof of insurance, which is very common, and no proof of registration. I call these driving while poor. So let's take a look. Thank you. That ought to get me through. All right, Mr. Taylor, you got a ticket. On December 6th in the city of Three Rivers at 9 o'clock at night for reasons I don't understand. It was a deputy sheriff. It was in the city of Three Rivers, but it's written under state statute. Driving without a license, as I said, is a misdemeanor. It's punishable by up to a year in jail, up to 90 days in jail and a fine of up to $100, 2 points. No proof of insurance is a civil infraction. That carries a fine of $150. And no proof of registration is also a civil infraction. And that carries a $105 fine. Let's see why you don't have a license. You have a previous conviction in 2023 for driving without a license. You have another one in 2016. So you haven't had a license for quite some time. I guess, Mr. Gibson, what I would propose here is perhaps we'll see if we can get a prosecutor to speak to him at a pretrial conference. Mr. Taylor, you live in Three Rivers?
I do.
How'd you get here today?
A friend brought me
All right, where are they?
over to the coffee shop across the street.
All right, let's make sure you didn't drive here. All right, we'll see, May, if we can get the prosecutor to talk to you. Have you done anything to get your insurance or registration squared away?
I have the registration with me. The car wasn't my car.
Okay.
So I didn't realize, I couldn't find the papers. The car is insured because just got the tags. The tags were due in
All right,
first
so
of
it
January.
wasn't your car.
Pardon?
It was not your car, but it's now registered and plated.
Yes, it was at that time also. And the new tags were just put on, or the new gate tag was just put on December 1st. And in Indiana, it's registered in Indiana.
Oh, it's an
Indiana, you've got to
Indiana
have
car?
insurance before you can get your tags.
All right, you have a seat for a minute. We'll see if we can get somebody to talk to you. Let me take a look at it, but I'll save you another trip over here. We're gonna make sure that you didn't actually drive here. Okay. We're moving at a snail's pace here, but sometimes that's how it goes. Mr. Rouse, would you join me, please?
Okay.
Appointments are done live. But this defendant has some significant medical problems. And I allowed him to come in by Zoom because he'd had difficulty getting here. You need to turn your camera back on.
I don't know how to do that, Your Honor.
Well, it was on when I saw you the first time.
I know, and my phone's been sitting on the couch, and now I don't have the video.
All right, well, let's talk about this. Are you Scott Harry Rouse? Sir? Now you muted your microphone, so we're even worse off. We're blind and deaf.
Okay, how's that?
Better. All right, are you Scott Harry Rouse?
Yes, sir.
Mr. Rouse, you got a ticket in Three Rivers under
Yes.
ordinance. I don't know why they set this for Thursday because they aren't here today, but you got charged with driving suspended. That's our most common offense.
Well, my ticket says revoked.
Well, you are revoked. You have multiple drunk driving convictions, which cause your license to be revoked. But this is the same statute. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record, and it requires that your license be suspended. They say this happened on January 15th.
Yes.
How do you plead to that charge?
I plead guilty to it with an explanation.
All right.
When I got
Did
sentenced,
anybody promise you anything to get you to plead guilty to this?
no, but I mean, I don't have a license, but I was unaware of it at that time. I went to court to be sentenced for the impaired, and that was in 2024. I went through the sentencing, which was 3 months restricted, and paid all my fines, and I thought it was behind me. I mean, when I got pulled over on the 15th, I was going to appointment with Pivotal that I have frequently, and then I was going to go to the pharmacy. And
Yeah, you were near. How come you can get to Three Rivers for your pivotal appointments, but you can't get to court?
because I could drive, I thought.
Okay, all right, you thought you could drive. Yes,
Yes.
they revoked your license. When you
I-
get two drinking driving convictions within 7 years, they revoke your license. You got one in July of 2024, and you had another one in 2021. So they didn't tell you, but that would cause your license to be revoked. So at the time you got this ticket, which was January 15th, you were revoked. Or I guess I understand you can't get here because you're on oxygen and you no longer can drive and you live in another county. All right. Did anyone promise you anything to get you to plead to this charge?
No, but.
All right, well, just a minute.
If I'm revoked, I didn't know.
Go ahead. You're revoked. They've taken your driver's license for at least 5 years. For all of you, if you get two drunk driving convictions within 7 years, your license is revoked. Unless you do sobriety court, there's a way to get your license with an interlock. All right, I'm gonna tell you some things. I'm gonna tell everybody in the courtroom. Do you understand that by pleading to this charge, you're giving up your right to have a trial in front of a judge or jury? That will not be a trial. Do you understand that?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson, the public defender, is here, but you could also have an attorney appointed to represent you if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court. Excuse me. So they could be questioned under oath. And you would have the right to take the witness stand yourself and testify, but you don't have to because you have a right not to testify. If you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. So you were going to an appointment at Pivotal on Millard Street, and you were then going to go to Walgreens?
No, Fred's.
Fred's, all right. And you live in Cassopolis?
Yes.
You now understand you can't drive anymore?
Yes.
All right, I'm going to give you a $100 fine, a $75 crime victims' rights fee, and a $50 state minimum fee. That's $225.
Okay.
Can you pay that within 30 days?
Yes.
All right, I'll give you a little more time. I'll give you till the end of March. That's due by 3/29/26. Is your address still South Street in Cassopolis?
Yes.
Does your phone number still end in 0319?
9498. It's 718-949.
But we have your correct address.
Yep.
All right, let me repeat. You just pled guilty to driving revoked or driving suspended on January 15th. You indicated nobody threatened you or promised you to get you to plead to this charge. I allowed you to appear by Zoom because you live in another county and you're presently on oxygen. I could see you when you logged in earlier. You had your oxygen equipment hooked up and you lost your license. So normally everybody else is here live, but you had a special dispensation. You owe me $225 by the 29th of March. Do you understand?
Yes.
I will send you notice. All right, Mr. Rouse, this matter is completed. Don't drive anymore. Sorry about that.
I have
All right.
I have a form here from Secretary of State on how to request a hearing to see if I
Yes, you
can
can
just
ask-
get it. So I can just get
Ask
it.
for a hardship license, but unless they do that, in our county, we probably would have looked at you for sobriety court placement, but I'm not sure what they did in Cass. Anyway, you're good to go.
I do thank you, Your Honor.
Thank you.
Good morning once again, everybody. Happy Friday Eve. Welcome to TCF Live. Great to have you all here today. Courts are starting to get their days rolling, especially up in Michigan, but we'll ride with Judge Middleton for just a little while longer.
Stand up for the whole morning. The next person to check in is Raina Moyer. Would you come forward, please? Why don't you give her a hand there, deputy, and let her sit at the plaintiff's table. Are you Raina Michelle Moyer?
Yes, I am.
This is file 252615SM. And 2614 SM. And you got a ticket. Ms. Lemmerhart, nice of you to join us. Well, let's talk about this case first. We got about 9 of these today between arraignments and pretrials of people driving with no insurance. Often is combined with driving while suspended and having an improper, well, you're also charged with driving without due care and caution. Let's take a look at your ticket. They say this happened on 4:38 p.m. on M60 and Corral Road by the big curve. That you were driving while suspended, driving without any insurance, and driving without due care or caution. Can't tell whether there was an accident or something.
Sir, I had a seizure. I was about a block away from my house.
Okay.
And I hit 2 trees doing, I had my cruise set at 60 and I took on 2 trees and I was hospitalized with a broken chest plate and foot.
All right.
Your list, sir.
What?
Your list. You have it.
Oh, yeah.
Thank you.
All right.
But
Well,
that's what caused the accident. It was a focal seizure, which I am epileptic. I've been seizure free for 5 years and it came out of nowhere.
I'm sorry to hear that. You weren't supposed to be driving because your license is suspended and you didn't have any insurance.
I can plead guilty to the suspended, but I did have insurance and we're still trying to get it. It totaled out my whole vehicle.
Well, it's a big deal. And I say this a lot. When you're driving without insurance, if you're in an accident with somebody else, their insurance company is going to sue you. What kind of car were you in?
A Chevy Traverse 2017.
So that's a valuable car. If you don't have any insurance, they're going to pay anything.
Well, they did and put us in a different vehicle.
All right, so you do have insurance?
Yes, I'm trying to get it. That's why I'm not guilty on the insurance part.
All right, well, what we'll do is we'll set this for a pretrial. 2526. The vehicle was totaled?
Yes.
How long were you in the hospital?
6 days. They took me to Three Rivers and then transported me to Borges. And I've been in and out of doctor's offices and appointments for the last 7 weeks.
But has insurance. Let's talk about that. The charge of no insurance is not under the motor vehicle code, it's under the insurance code. It's punishable by up to a year in jail and a fine of up to $500. Fine is not less than $200 plus cost. So the minimum fine is $325. It also requires that you get fingerprinted.
I did that
Driving,
already.
all right, driving suspended is a misdemeanor, punishable by up to 93 days in jail and a fine of up to $500. We have lots of each of those today. Driving suspended carries 2 points. I'm going to ask everybody who's here on no insurance, do you have insurance now? And you do have insurance now, but you don't have the proof with you. So I'm going to set this out for a pretrial. You live in Leonidas?
Yes, sir, with my kid.
Okay, well, I'm glad you're still here to be here.
Me too.
I'm going to set for pretrial February 26th, 2026 at 8:30. Now, you also have a retail fraud charge
What?
that you got a ticket and you didn't answer it, maybe because you got in this accident.
I don't recall any ticket
Well,
for that.
let's take a look at it.
Yeah, because I'm curious to know myself.
You got charged in the city of Three Rivers on August 1st of 2025 with a retail fraud.
I don't recall that. I'm sorry, sir.
Well, let me find it. And then you never answered it. They didn't charge you with a misdemeanor. They charged you with a civil infraction. And when I prepare my cases each day with the help of my staff, we look and see whether anybody's got any open warrants or whether they owe us money for something else. And there are several people today that have other issues. And
Well, I'm willing to take care of that now that I know about it.
well, let me tell you what I do know about it. I thought I had a copy of it, but I couldn't find it. I asked for it, and I don't know what I did with it. It was at Walmart at 3:32 p.m. And they gave you a ticket. Deputy or Three Rivers Police Department Gavin Etter gave you a ticket.
I'm sorry, sir. I don't recall.
All right. Well, anyway, you didn't answer it.
I apologized.
They said we at the court sent you a letter and you didn't respond to that. So this case is kind of in limbo. All right, I'm gonna give you a court notice. And she wants to address all right. And this is Thursday. The Three Rivers city attorneys are here on Tuesday. So maybe I should, well, we'll see. Let's address retail fraud in 2516220M. Seems like that would be something that you would remember if you got stopped for shoplifting and they gave you a citation. But I'm not exactly clear what the deal is. So I'm going to have the court officer take you out to the counter. We're going to set a pretrial for February 26th. So you'll come back in about 3 weeks. Bring your proof of insurance.
Yes, sir.
And you might want to bring your medical stuff too. And you may then want to address this retail fraud ticket. Retail fraud is a misdemeanor under state law, but Three Rivers and Sturgis have an ordinance where they can charge it as a civil infraction. which means it's punishable by a fine only. So they handed you a citation, it looks like, and then you never responded to it. So maybe they can give you a little more information. Anyway, you're gonna get a formal notice and then you're gonna talk about that retail fraud charge.
Yes, sir.
All right, you're good to go.
All right. Court is calling 2025 CR 012673 and 2025 CR 015638, State versus Charlie Marquez. Can I have parties announced?
Right. State. Warren Wolf for Mr. Marquez.
And are you Mr. Marquez? You entered into a plea in each of these cases. You entered a plea of no contest. According to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. There's a $1,500 fine. State is opposed to your applications. They are running this concurrent with each case with a county court cause number 2024 CC 737959 and 2025 PF 09446. And taken in consideration will be 2025 CR 011814, 2025 CC 004665, and 2025 CR 011499. And in one of the cases, there's an affirmative finding of family violence. There was a TAP evaluation and a PSI report that was completed. Have all parties had a chance to review the PSI report and TAP evaluation?
We have, Judge. Yes,
Any objections to those documents, state or defense?
not for the state, Judge. No objection, but there is a correction about Mr. Marquez's recognition of his issues with alcohol. And he is willing to take treatment. In fact, he is, we'll explain that later. He's with CPS program now, and there is alcohol treatment being provided for him, and he's participating there.
All right. State, you're opposed. Do you have any witnesses?
No witnesses, Judge, just argument.
Defense, do you have any witnesses?
Mr. Marquez, bless you. And in addition to the documents that you have, and I've tendered these to opposing counsel, certificates of his participation in the Supporting Dads program, his taking drug tests that are negative, and his participation in the Family Violence Prevention Services, where he's been attending.
All right. Any objections to the court reviewing those documents? All right, it's not listed here, but when did he start the violence prevention program?
2 months already.
Okay. And I just asked because I saw where he was on the 7th class. All right. And you want to call your client?
Yes.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Charlie Marquez.
All right, Mr. Marquez, I want you to know that you may see me reading documents. It's documents that are related to your case. It's the PSI TAP evaluation, but I'm still listening to you and I'm able to internalize everything that you're saying, okay? All right, defense, you may proceed.
Mr. Marquez, I know there's a lot of issues that you've had in the past, but that is not who you are today, is that correct?
Oh, and I'm so sorry. Could you all speak up a little bit so I can hear?
Where are you currently working?
Work at a restaurant called Twin Peaks full time.
And what do you do there?
I'm a head cook.
And how long have you been working there?
Over 9 years.
And you are currently living with another lady, not the lady that was involved in the case that's before the court, correct?
Yes.
And the name of the person that you're with now? Well, you're not under this. But you're working through that through CPS?
Yes, correct.
How long have you been going to CPS classes?
CPS, I've been going to CPS for over a year, CPS classes for almost a whole year as well.
And what sort of things are they talking to you about there?
Counseling classes, substance abuse, drinking, violence, big, re-entry program.
What is the goal of those classes regarding you and your children?
To reunite the family.
And your daughter, right?
Yes.
Where is she currently staying?
They're staying with my mom.
With your mom, not
Yes,
their mother's
Yes.
mom, correct? There was an issue with her, what was her name?
Crystal.
Crystal, that she had some drug issues, correct? So CPS thought it wiser that the children not be with either you or her, right?
Yes.
And they're with your mother. Do you get to see the children?
Yes, every week.
Is it supervised?
It's supervised 2 hours with my mom.
And has there been any issues in that regard?
No.
I know you said that you've been taking some substance abuse classes with CPS. I noticed also, we showed the judge some documents that you've been tested. Have there been any positive tests since you've been going through these programs?
I think over a year or so. Last year, maybe it's just one, and that was it.
And since then,
Oh,
you've been sober.
yes.
And that is where you know you need to be.
Yes.
You know that is a major issue with your situation. All these cases that are before the court, whether they're being taken into consideration or the ones that the judge has to rule on and make a decision what happens to you going forward. Alcohol is a major issue that you need to confront. You understand that,
correct?
And you are doing that.
Yes.
And you're doing that successfully, correct?
Yes.
I showed you some of the programs that the court could place you under that have been indicated by probation. Are you willing to abide by any of the conditions that the judge may impose on you in order to keep you in the community and towards reuniting with your family and helping to provide for their financial support?
Yes.
Is there anything else that you wanted to tell the judge?
Just I have a problem with alcohol.
Questions, Judge?
Yes.
Can I call the, Mr. Marquez, can I call you Charles?
Yes, that's fine.
Okay, all right, Charlie. Well, first thing, let's just be honest right now, because honesty is the best policy. If you're dishonest, we're gonna sniff out right here, so just be upfront with my questions. All right, let's talk about Crystal. How long were you in a relationship with her?
We've been married over 14 years.
Okay. Are you living with her right now?
Right now, she's currently employed and out of the house. But with
But you're not under the same roof.
Yeah.
Just listen to his
All right,
question.
yes.
Okay. All right. Let me ask you, did you ever contact her?
We have we have to be in contact only for the visit for the kids.
For the kids? Okay. How many kids do y'all have together?
We have two.
Two? Okay. Boy, girl?
You got two boys.
Okay. How old are they?
One just turned 13, the other one is 10.
That's gonna be a ripe age for two boys, man, right? Okay. Let me ask you, so when you're communicating with her, did you ever tell her about not talking to the DA's office?
I went to the evaluation last week and I told her she was supposed to call I forgot his name, Doug, to about a statement.
Okay, and is
about
that
probation.
is that the have you ever heard of something called an affidavit of non-prosecution?
No.
Okay. All right, let's talk about, because we got a few cases, one of which is involving Crystal. So let's talk about the first one. Did you get deferred adjudication for an assault family violence?
For the first case, yes.
Okay, was that with Crystal?
Yes, correct.
Okay. What about the second case, man?
It's also with her.
Okay. let's talk about, so I was reading the PSI, you were saying in there that you had no alcohol problem, right?
Yeah, because, yes, right.
Okay, but you also said that your alcohol use has increased over time?
After my brother passed away, it's been a year this coming week that he's been passed.
Have you tried to stop using alcohol?
Yes.
Okay, have you been successful?
Somewhat, but I do notice that I do have a problem.
Okay, what do you mean by somewhat? Did you go for a little bit and then fall away?
Yeah, because like I said, it's been just a year now. My brother passed. It's been hard on our family.
Okay, I get it. Was your alcohol use a factor in that evading with the vehicle that you got back in July 26, 24?
No.
Were you intoxicated that night?
I made it home, got out, and he was it blood test me when I got into the Fair County.
Okay.
And I had alcohol in my system.
Did you stop for the police?
I had stopped the light. He pulled over next to me, but he never turned on the light. I was waiting at the light. Turned green. I turned, but he never pursued.
Okay, so why is there an evading with the vehicle then?
They caught me in my apartment.
So you drove, so the couple up next to you and then you drove home?
I turned up the light whenever the light turned green.
Okay, Matt. Let's talk about March and April of last year. How many cases did you pick up during that month?
I think it's 2.
So let me walk you through it. So on March 12th, 2025, you got a case for possession of controlled substance, PG1, 4 to 200 grams. A week later, you got your second assault family violence with Crystal. And then on April 2nd, you got a PG1 less than a gram. So within a month, you picked up 3 felony cases, one of which was violence. What was going on?
I was trying to go take our kids to school. So the family, the violence, and I called the police, and I ended up getting a warrant for my arrest, and I turned myself in.
Okay. You have a problem with your problem with substances?
Not no more.
Okay. What was going on? What kind of substance did you have that month in March and April?
It was cocaine.
Cocaine?
Yes.
I think on your PSI you said you used cocaine when you were 18, but you didn't bring up that you were using cocaine last year. Why was that?
I just said I didn't. So I had told them on the possession that somebody was in my car and they left their bag in my car.
You think when you're talking to the interviewer, it's important to be upfront with them?
Yes, I did state that somebody left bags in my car.
But now you're telling them that you haven't used cocaine since you were 18, but you just admitted that you had it on you last year.
I wasn't doing it.
What were you doing with it then?
I was in my friends, and I was in my car.
So it wasn't your coke, it was somebody else's?
Yeah, correct.
Okay.
You've been tested for us at Center for with CPS. Is that right?
Yes.
And have they tested you for drugs and alcohol there?
Yes, correct.
And they've all been negative. You have not used cocaine or any of that while you've been seen by CPS, correct?
Correct.
And if they tested you today, you would be negative, correct?
Yes.
Okay.
Just had a drug test last Tuesday, Friday, Saturday. Friday.
Okay. Do you think you could be successful if the judge put you under supervision of her probation officers, putting you through additional programs like you're doing now with CPS? Do you think you can, are you willing to do that? Can you do it?
Yes.
Why do you say that?
I'm the main supporter for my family, and there's no income coming in for either the kids or my wife.
What do those children mean to you?
They mean everything. There's only 2 kids that I got.
you realize, if the judge does put you under court supervision, any violation, if you would come back in front of her, I guarantee you it would not be good. You understand that?
Yes,
Do you still want the judge to grant your application for community supervision?
yes.
Questions?
All right, this is what I want to know, and if anyone wants to answer the question, great. If no one wants to answer the question, that's great as well. I am trying to understand. One, he stated to me that for the CPS case, the children have not been placed with the mother who's listed as the complainant in this case. Children are placed with his mother. And that usually suggests to the court that there's some issue. Now, I know sometimes people will stand before me and say, oh, I lost my children because my partner was abusive or something like that. And usually that doesn't happen. So I'm trying to decipher and read between the lines what's going on here, because the state's stipulated evidence that everybody agreed to, we have some incident that occurred after his workplace. So I'm trying to figure out, how do we get from she goes to see you where you work, and I'm assuming, I don't know if the children arrive with her or not, everything is fine. Your new girlfriend or wife or whoever she is shows up, informs her that she's expecting. According to the stipulation, she said it was a great conversation. And then we have you going to the mother of your children's apartment, and confusion results. And I'm just saying confusion instead of saying everything, but I reread the steps. And they're saying this happened at 7:50 on March 18th. What day of the week was that?
Which year, Judge?
2025.
What day, Judge?
March 18th, 2025.
That'd be a Tuesday.
All right. So his testimony was that he was going over there to take the children to school. Was his testimony? I think that's what he said.
So,
All right. So I'm just trying to figure out credibility here. So being at that apartment at 7:50 on March 18th, maybe he was there to take the children to school. I don't understand how we get from you're there to take the children to school to this incident happening, and then you're leaving the location. Were the children taken to school, or did you leave the location without taking the children to school?
I left the location without taking children to school.
All right. And so there is a lot that's missing from the stipulation that I would like answers to, but it was still sufficient enough to find you guilty of the offense. So how long have you been involved with Child Protective Services?
For a year already.
All right, over a year. So your rights have not been terminated? Did they give you an extension?
I got a court date in April and the deadline is for May. Around May.
All right. And so the mother of the children, do you know whether or not, because I know y'all will probably go to court together, do you know if she's completing her service plan?
Yes, she's doing her services as well.
Okay. And outside of court, have you had any, and when I say outside of court, outside of the CPS court hearings, have you had any contact with her?
Just to pay bills, basically. But she's not employed.
Okay. And when you say the pay bills, what bills do you mean?
Cell phone, groceries, food, whatever. She has like basically homeless without me. So she has no source of income.
All right, and what does your new wife or girlfriend say about that?
I don't no longer talk to her anymore.
No longer talk to who?
The friend.
Her name?
Oh,
No, I mean the new woman that was in your life that's in the stipulations,
yes, it was just a friend from employer.
but it says she's pregnant. No, in the stipulated evidence, it says this new girl shows up, tells the mother of your children that she's pregnant with your child.
Mhm.
And according to the stipulations, the mother of your children said it was a good conversation, everything was fine. She leaves, and then you show up at her home on Tuesday. What you say is to take the children to school. So where is that person?
I don't know. She just calls me every once in a while, but she's not pregnant.
Okay.
Yeah.
Judge,
Yes.
let me ask a few more follow-up questions of Mr. Marquez.
Yes.
All right, so, Mr. Marquez, so this new assault family second charge is against Crystal, right?
Correct.
And you said you're not living with her?
Right now she's living at my apartment.
I'm sorry, what, living where?
She's living in my apartment where I'm paying.
Okay, she's living at your apartment.
So you are in contact with her?
Like I said, I have to, yes, I have to, because I have to pay the bills.
Okay. Wow. This week. She's fine, like. Judge, we'd like to show you the conditions of bond and the assault family second that we were talking about with Miss Crystal Vasquez. And on there, it explicitly says that there is a no contact order in place between Charles and the person named here. So he's just admitted on the record to you to violating his conditions of bond.
All right.
I do have another lawyer for CPS case. He supposedly picked up the violation for the no contact order.
All right. So who's that attorney?
I gotta look up my phone. If we do have to meet.
Dale Hill.
All right. So we're going to take a short recess, and this is what I want attorneys to find out. It should be easy to find out. If somebody can call Dale Hill, or if somebody can have a CPS caseworker Zoom in here, because I want to see if what he's telling me is the truth regarding where he is in the CPS case. Because I would regret to leave children unsupervised, or they're going to be in foster care or something of that nature would happen if people have changed. So if somebody can get in touch with Dale Hill, get in touch with the CPS worker, and if there's no objection to them zooming in.
I'll just get the Zoom number. from
All
the
right,
clerk,
thank
and I'll
you.
get,
And then I'll take this matter up.
have a seat. Oh, yeah.
Okay, friends, to be continued. The good news is we got about 2 hours worth of show yet, so we should be able to find out more. In the meantime, let's go to Louisiana, give the parole board a try.
The Committee on Parole is now at the Terrebonne Parish Detention Center. Good morning, Mr. Lacoste. Your mic's on mute.
Yes.
There you go.
Good morning, Ms. Renata. How are you today?
I'm good. Thanks for asking. Would you tell us your name and DOC number?
My name is Leopold Charles Lacoste II. My DOC number is 478688.
All right, thank you, sir. And I see you have counsel with you this morning. You have, I'll let you all, Ms. King, would you introduce yourself first?
Good morning, Teresa King here on behalf of Mr. Lacoste. We refer to him as Chuck. That's his nickname, but I am counsel of record here on the pending charges in Terrebonne Parish, as well as for the purposes of this parole revocation hearing.
Okay, and we also have Miss, is it Lizzie King?
That's correct, Your Honor. Elizabeth King, I go by Lizzie. I too am one of Mr. Lacoste's attorneys. I work with Teresa King and we represent him in Terrebonne Parish and for purposes of this parole hearing.
Okay, great, thank you. Yeah, so we are here for a revocation decision this morning. Mr. Lacoste, your case has been assigned to Mr. Tillis, so he'll read the allegations and ask for your plea, and then we'll proceed from there. Mr. Tillis.
Ms. Renata, it was to my understanding that this was being continued for us to be able to get people that I was supposed to have people here on my behalf and whatnot. And according to the paperwork that I was given, and when I'd spoken to my attorney over a month ago, this was, we were supposed to be requesting a continuance on this hearing for us to gather the information that we needed to proceed with this particular event.
I have no information in my records requesting a continuance. Ms. Teresa King, have you submitted anything?
No, ma'am. We were recently hired to represent him on the parole matter, although we did speak to him about it and attended the preliminary hearing at the jail. Miss Allison Leeret had informed us that a continuance was not likely because the parole board wanted to move forward. And then the latest information that I received before I was hired was that Mr. Lacoste had requested a continuance in writing directly. So I don't know if anything was submitted by Mr. Lacoste prior to us being hired.
Well, I think we have enough information to proceed this morning, Mr. Lacoste. So I'm going to go ahead and turn it over to Mr. Tillis.
Okay, good morning, Mr. Lacoste. How are you?
Good morning, Mr. Tillis. Good morning, sir.
We have some violations that I'm going to read. You can plead guilty, not guilty, or with a statement. Violation number 3, you left the state of Louisiana without a written permission from your parole officer as evident of a tax documentation. Certain gambling winnings from the Golden Nugget Casino located at 151 Beacon Boulevard, Biloxi, Mississippi, dated 4/11/2025, and bank transactions on the following dates: 8/11/2024, 9/7/2024, 11/23/2024, 1/3/2025, 1/19/2025, 2/2/2025, 2/2/2025, 3/20/2025, 2/18/2025, 2/27/2025, and 4/11/2025. On or about 4/14/2025, you were engaged in criminal-like conduct as evident by your arrest by the Terrebonne Parish Sheriff's Office on charges of violations of protective order, charges of a violation of protective order, theft of $25,000 or more, felony, and exploitation of the infirmed, a felony. The current charges, imploding of this infirm, $25,000 or more, violation of a protective order in Terrebonne Parish. How do you plead? Guilty, not guilty, or guilty with a statement?
Well, to which portion of what you read, Mr. Tillis, is
If I may, Mr. Tillis, Mr. Lacoste and I discussed at length that there are mitigating factors to explain the technical violation of leaving the state without written permission. And so he may want to admit to those allegations, however, plead not guilty to the new criminal charges of theft or exploitation of the infirm and violation of a protective order.
Okay, you want to explain it or talk about it?
Yes, please. And Chuck, just give me a minute to give an overview, and then you will have the opportunity to provide specifics. So with regard to the allegations that he was leaving the state without written permission, he was previously supervised by a parole officer who gave him leeway. He had written permission to leave to go see his mother, who lives on the Gulf Coast of Mississippi, and went to see her multiple times with permission of the parole officer. The parole officer told him, "You don't have to ask for written permission every time. I know you're coming back. It's all good." Then he got a new parole officer, Allison Liebert, who was much more strict, black and white, with her following of the rules, and you need to get written permission every time you leave the state. And the summary and recommendation that was submitted by Ms. Liebert actually has included a statement from Dr. Linda Thibodeau, who is Chuck's mom. As it pertains to the criminal charges, Mr. Lacoste was accused by his aunt of using her debit card or bank account without her permission, although they lived together for multiple years, and she permitted him to use her account in a variety of circumstances. He never used it without her permission, but when other family members discovered their arrangement, they became upset and involved the police, believing that their mother had been taken advantage of. After his arrest for theft or exploitation of the infirm, a judge issued a no contact order as a bond condition. Mr. Lacoste never bailed out and therefore was never subject to said bond condition. And when he was accused of violation of a protective order, it was because there were allegedly phone calls made to the alleged victim. No threats, no harm, but a phone call from the jail from Mr. Lacoste to the alleged victim or family member. And that's the extent of the violation of a protective order, which we believe is not a valid charge because there was no protective order in place. There was no court order stating that Mr. Lacoste should not have any contact with a specific person. If there was an order, that order was not served on Mr. Lacoste. Having no notice of said order, he should not have the criminal charge of violation of a protective order. All that also should be noted that he's innocent until proven guilty, has not been convicted of the new charges against him. And we would ask that this board not revoke his parole on the basis of mere allegations.
What about leaving with his new parole officer without written permission?
Mr. Lacoste, do you want to explain?
May I speak? May I speak now?
Yes.
Mr. Tillis?
Yes.
Okay. Yes, sir. Okay. So I provided to my attorney, first of all, my attorney does have some dates that Ms. Liebert claimed that I was away and hadn't gotten written permission to leave, and that I did actually have written permission to leave. My attorney has copies of that in her file that she had, on some of the dates she read out, said that I had left without written permission when I did have written permission. The other thing, sir, is my father got cancer, okay? And my prior parole officer allowed me to come and go, yes, sir. And I always worked, I always came back. I mean, I never did, as far as any of that's concerned. The thing is that also some of the time now, yes, in fact, I did have a player's card with the casino, but my aunt that I was living with was taking trips to the casino and using my card to get the free play off of it. And so were my parents. And that's why I asked for my parents would say that as well, that they use my card from time to time to get the free play off of it when they would go there. But the other thing was that my attorney also has a copy of my call log to Miss Allison Learett from my cell phone, because she's in possession of that and has been since my arrest. And the thing is that I did try to make contact with Miss Learett, and every time that I did, and she didn't call me back. Miss Learett was out for surgery. She was out for several other things that I didn't know about until later. But in any case, I had also requested Mr. Jason Knockan, who was my prior parole officer, to come to talk to you as well. I mean, about all of this. My father came down with cancer. He's 88 years old. My mother needed help. She's 85. And yes, I tried calling Allison Learett. And yes, I would go to my parents' house. And every time I went to my parents' house, I did work around the house that they could not do, and then came back to take care of going to work here. And so, I mean, I hope I'm answering your question, but I'm trying to give you the explanation. I was not trying to not ask. I was not trying to not follow Miss Learett's request. But when I called for Miss Learett and Miss Learett wouldn't return my phone calls, I don't know what else I was supposed to do, sir. I mean, my father was going through chemo and radiation treatments, and he's, like I said, he's 88 years old, and they needed help. And
So you were not going to the casino?
Mr. Tillis, I did go to the casino, but I didn't go to the casino all that as many times as Miss Learett said I did. And yes, I did. I went to my parents' house, and sometimes my parents would say, hey, let's go get dinner or whatever after I did work around the house. And maybe we went by there once or twice when I went to their house. But I did not go to like I said, this is all coming from information from the player's card and all that. And my parents used the free play that I got from that player's card, and so did my aunt when she would go. And so I'm not saying, Mr. Tillis, that I didn't go, because I did. Yes, sir, I did go, but I didn't go as 10 times or whatever she's got on there that she's saying that I left and went to a casino. That was not what was going on, sir.
Okay, and you said they were supposed to come and verify that? Your aunt, your mother?
Well, my mother would be happy to testify under oath that yes, they've used my player's card. My aunt used my player's card. But the thing is that when they pulled the record from the casino, it showed every time that it was being used. So it was me there, and that was not the case, sir. And on those dates, like I'm saying, my attorney has some permission slips for me to go to Mississippi to my parents that she's accusing me of leaving the state and not having permission. I have no problem, no issue telling you the truth about the fact that, yes, sir, I did do that, but not like that she's saying I did. Okay, that's not how it happened. And from what I understood, from what I understand, that me having done that, that was a technical violation, not a revocation.
Okay.
I mean,
and if I may add something briefly, Mr. Tillis, Miss Learett and or Trina Williams, who participated in the preliminary hearing, did speak with Agent Jason Knockan, and it is in the summary that he provided the following statement. As far as I know, the offender remained in compliance with no reason to violate him for absconding supervision. And his mother, Dr. Linda Thibodeau, also provided a statement and said that her husband Donald was diagnosed with cancer, that Chuck came and he tried to call Allison repeatedly and did not always get a response. And his mother, Dr. Thibodeau, also provided a statement regarding her sister, June, who is the alleged victim of the theft or exploitation of the infirm, indicating that June had never said anything about a financial issue and that she is now listening to her daughter, Shelley, who prompted the criminal investigation. So the witnesses are not present here to testify. In my research in advance of this hearing, I did not find a process for subpoenas, and I apologize, this is my first time handling a parole hearing by Zoom, but certainly Miss Linda Thibodeau and her husband Donald would be present if they were tech savvy or were ordered to be here.
Okay, all right, thank you.
Thank you.
Let's move on to the next violation. Violation number 4 on or about 4/14/25, you were engaged in criminal conduct as evident by your arrest of Terrebonne. Did I read that?
Yes, sir, you did read that?
Yeah.
Sir, I am not guilty. I am not guilty of violating any protective order because I never had a protective order. And even furthermore, I never spoke to my aunt since I've been arrested. And so I don't even, none of it makes any sense. The judge that set my bond said that if I bonded out, a condition of my bond was a no contact order with my aunt. I got arrested. And furthermore, I got arrested. I did make an attempt to make a phone call to my aunt. I did make an attempt to talk to her, but that was before I'd even been told about the bond, the condition of bond. And so then they said that I violated a protective order and added another $25,000 to the bond. But then I couldn't bond out because Allison put a parole hold on me. And so I never bonded out, sir. I never violated any protective order, sir. I never did. And once someone told me, I never even attempted to call my aunt again. I didn't.
I hear you. Miss Liz, you want to address any of this?
I believe that that Ms. Teresa King has addressed everything very thoroughly. I'm mainly going to defer to her and to Chuck's testimony. The attempted call to his aunt was before he was aware that there was a protective order in place. You don't know what you don't know. And afterwards, he was incredibly diligent. He's always been very diligent, and he was diligent in following the instructions from that protective order. And then just to reiterate, I know that we've passed this issue already, but just to reiterate, even if he went to a casino one time, that is just a technical violation. And as Chuck and the other Miss King have noted, is a technical violation, not a reason to revoke his parole.
Thank you. At this time, I'm going to ask for an executive session, please.
I'll second. Any objection?
Nope.
All right. Mr. Lacoste will be in executive session for a few moments to discuss confidential matters.
Ms. Renata?
Okie dokie. While they do the executive session, let's go back to Judge Boyd because I believe that the guy we were watching earlier is back in play now.
Both attorneys told me that they've spoken to you or Mr. Wolf has spoken to you. I'm just trying to find out specific information. Mr. Marquez told the court under oath that he is doing well with his CPS case, that he's been having visitation, and I don't know if the mother's doing well or not. I don't want to derail a reunification or have the children just out with non-family members if I were to send him to prison, if he's doing well.
Yeah, Judge, according to the last permanency hearing we had, he was in compliance, and we're set for trial in May.
Okay. And can you just tell me, and we're not on the record or anything, how is the mother doing?
Let me see real quick, Judge, if I can look at the compliance. And I'm trying to think off the top of my head with this. I was trying to look at this report to see if she was in compliance or not.
And could I have the Marquez file back, please?
Well, of course, as soon as
There's no clip. No problem. Thank you.
Judge, I apologize. I'm just trying to bring this up real quick.
Yep.
Generally, okay. Per the permanency hearing, it was the mother demonstrated adequate and appropriate compliance with the service plan.
Okay. All righty. And has your client been having visitation with the children?
Yes, Your Honor.
And are the children placed with his mother?
Yes, with paternal relatives.
All right. Thank you so much, Dale.
Thanks, Judge.
Questions.
I don't get about on that side much anymore, so I'll pop in next time.
At least stop by to say hi.
I'll do that. Thank you, Judge.
All right. Thank you. Have a good one.
See you. Thank you.
All right. Thank you. Are you all ready to proceed?
We are good.
All right. We're back on the record in 2025 CR 015638 and 2025 CR 01263, State versus Charlie Marquez. Can I have parties re-announce?
Brandon Brady for the state.
Warren Wolf and Mr. Marquez.
And you're Mr. Marquez. All right. We were not on the record, but we did have Mr. Marquez's CPS attorney zoom in. And as an officer of the court, he presented the court and both parties with updates on the CPS case. And according to his rendition, Mr. Marquez is in compliance and that the children are residing with the paternal grandparent. All right. So this is what I want to stress to you. There is a no contact order, and the no contact order is in force. The only exceptions usually for a no contact order is if you are in court. So that is the only contact you can have. And you can pay bills for an apartment that somebody is staying in without having contact. You either send it by check, money order, but you do not need to go to the location. You can pay any type of utilities. And the last time I lived in an apartment, I think sometimes the utilities are included with the payment or it may be separate. But if your name is in the utility bill, you can pay that online. You are not allowed to contact her outside of being in your CPS court hearings. Do you understand?
Yes.
If you do that, you will violate any probation that I give you. And then you're looking at doing time. And when you're looking at doing time, maybe your parents will be able to take care of your children, maybe not. They may end up with their mother. And somebody else, some other man will come in to raise them. Do you understand?
Yes.
Judge, would you be willing to entertain a motion to modify that no contact order?
No.
I just, if that's the solution, I can do that.
Yeah, no. All right. So this is what the court is going to do. Let me see. I'm trying to find your application. Did he apply for deferred adjudication? Just regular? All right, this is what the court is going to do then. And cause number, Odyssey again. 2025 CR 015638. Probation, are you ready? Court is going to is finding you guilty. Court is going to sentence you to 8 years in the prison, suspended and probated for 8 years. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. There's to be CPS compliance. There's to be no contact with the complainant. There's an affirmative finding of family violence. There's going to be GPS tracking, waive fees. That is to be installed no later than February 10th, 2026 at 3 p.m. This run concurrent with 2025 CR 012673. 2024 CC 737959, 2025 PF 09446, taking consideration 2025 CR 011814, 2025 CC 004665, 2025 CR 011499. There's to be field visits 1 time per month until further notice. There's 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. CPS parenting classes, which they should have ordered, will be acceptable. Probation, is there anything else with regards to that case?
Judge, the only concern that I have was that it was mentioned that he's supposed to have some type of surgery on the 13th, I believe, or the 16th.
That is correct. When is your surgery?
13.
All right, so the GPS is to be installed after clearance, after medical clearance.
Thank you.
All right, and then there's to be the BIPP course.
I think he's already either taken it or enrolled.
All right, he'll need to provide proof of that to probation. And probation, he's currently in a family violence course. That family violence course will be acceptable to the court. And that cause number, did you review the document entitled Trial Court Certification of, state your excuse.
Thank
Thank you. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it in that cause number?
Yes.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. We're moving on, and cause number 2025 CR 012673. Court is finding you guilty. Court will sentence you to 8 years in the prison, suspended and probated for 5 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. There's to be installation of GPS, and that will be tracking, waive fees, and that's to be installed after medical clearance. And Adriana?
Yes, ma'am.
I know you all have to put times in there.
Yes,
So
ma'am.
it's GPS until further notice.
Yes, ma'am.
This will run concurrent with 2025 PF 11276. And probation, I believe that cause number is the CR number that we just did. Taking consideration 2025 CR 011814, 2025 CC 004665, 2025 CR 011499. There's to be 200 hours community service restitution. You're going to take the defensive driving class. Once that's completed, the community service hours will be deemed satisfied. There's to be field visits 1 time per month until further notice. Probation, is there anything else? And I'm sorry, there's a $1,500 fine and that will be probated. Is there anything else you need from the court to be successful?
Thank you.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. In this court, to be successful on probation, communication is key. If you had a misunderstanding about the no contact order, you now know you're not allowed to have contact with her unless you're in civil court. And what does that mean? That means you're not talking to her in the hallway because she has an attorney, you have an attorney. You are to be in the courtroom. That's it. You are not to go to your other apartment. If that apartment is in your name and you're paying bills and you're being nice and allowing her to live there, you can pay that bill, send it in to the apartment complex. You can pay the utilities online, but you are not to have any contact with her while that protective order is in place. Do you understand?
Yes.
Is there anything you do not understand? All right, good luck to you.
Thank you very much, Judge.
Thank you. Oh, do I have the cases that were taken in consideration?
I believe Mr. Prager is putting that together.
All right, thank
He
you.
also has a matter in County Court 4 I need to.
All right,
deal
thank
with.
you.
All right, we are ready to begin. Everyone, thank you for your patience. We've been waiting for 21 minutes, but I think we're ready to go. Our first matter we're going to address is People versus Mucio Gomez Arias.
El primer caso que vamos a tratar es el de Lucio Gómez Larios.
Is that you, sir?
Don't ask me.
¿Es usted, señor? Yes.
The man on the screen is Pablo Bello. He is a certified court interpreter.
El señor en la pantalla, el señor Pablo Bello es el intérprete certificado.
And he's going to assist us this morning.
Y él nos va a asistir esta mañana.
We're just setting for last pre-trial.
All right. Senor Bello, do you swear or affirm to the best of your ability you interpret these matters from Spanish into English and English into Spanish?
Yes, I do, yeah.
Senor Gomez Arias, you got 2 tickets for driving without a valid operator's license.
Señora Arias, usted tiene 2 multas por manejar sin una licencia de manejo, o sea.
One ticket was written under state law.
Una de las multas fue escrita bajo las leyes del estado.
And file 24941 ST.
Es la forma número 2 ST, dice.
That happened allegedly on May 27th of 2024.
Esto sucedió el 27 de marzo del 2024.
You didn't appear for your arraignment.
No se presentó para su arraigo.
And a bench warrant issued for your arrest.
Y entonces el juez emitió una orden de arresto en contra suya.
A year later,
Un año
on
después,
September 29th of 2025,
un año después, septiembre 25 del 2025,
you got stopped again for driving without a valid license.
lo detienen de nuevo por manejar sin una licencia de manejo
And speeding.
y por manejar exceso de velocidad.
When you came to court on that case,
¿Usted vino al tribunal para ese caso?
you got arrested on the bench warrant on the earlier case for not showing up for your arraignment.
Lo arrestaron ese día porque no se presentó al arraigo que ya tenía.
So one of these is from the city prosecutor and one is from the state prosecutor.
Uno es del el fiscal del estado y otra es del fiscal de la ciudad.
The city prosecutor has agreed to dismiss their case.
El fiscal de la ciudad le va a retirar los cargos que le hizo.
Which is file number 252020OT.
Ese caso es el 252020OT.
That is the second driving suspended and the speeding case.
Ese es el caso de que le suspendió la licencia y estaba usted manejando a exceso de velocidad.
In exchange for dismissing those cases,
A cambio de que le retiren esos dos casos,
you're going to plead guilty to the 2024 case of driving suspended or driving without a valid operator's license.
se tiene que declarar usted culpable de que estaba usted manejando sin licencia de manejo en el 2024.
In Michigan, driving without a valid operator's license is a misdemeanor.
En Michigan, manejar sin una licencia de manejo es un delito menor.
It is punishable by up to 90 days in jail.
Se puede castigar hasta con 90 días de cárcel.
And a fine of up to $100 plus costs.
Y una multa máxima de $100 más gastos del tribunal.
And it carries 2 points on your driving record.
Y si tuviera usted licencia, le ponen 2 puntos en su licencia de manejo.
You are here with your lawyer, Ms. Casey Strong.
Usted está aquí con su abogada, la señorita Casey Straw.
Ms. Strong, you confirm the plea agreement?
Señorita Straw, ¿puede usted confirmar el acuerdo?
Yes, Your Honor, that's my understanding.
Sí, su señoría, eso es lo que yo entendí.
Senor Gomez Arias, anybody promise you anything to get you to plead to this charge?
Señor Gómez Arias, ¿alguien le prometió algo a cambio de que usted se declara culpable de este cargo?
Or threaten you to try to get you to plead?
¿O alguien lo amenazó para que usted se declarara culpable de este cargo?
No.
No.
You understand that by pleading to this charge, you'll be giving up all of these rights that you've signed on this advice of rights form in Spanish.
Usted entiende que si se declara usted culpable, usted está aceptando, está cediendo todos los derechos contenidos en ese documento, donde están todos sus derechos en escritos.
Now,
Yes.
This is actually the first of the two cases. This is the one from 2024.
Este es el primer caso de todos los casos que tiene, está fechado en el del 2024.
According to the ticket,
De acuerdo a
you drive
la...
a car on M66 near Jackson Road in Colon Township.
Sucedió en la carretera M66 en Jackson Road, dice el juez.
And they pulled you over for speeding and found that you had no valid license.
Lo detienen porque estaba usted manejando exceso de velocidad y se dan cuenta que no tiene usted una licencia de manejo válida.
Do you recall that day?
¿Se acuerda de ese día?
Where were you going?
¿Hacia dónde se dirigía, señor?
Al trabajo.
I was going to
And
work.
where do you work?
¿Dónde trabaja?
Hoy trabajo en construcción, pero nos vemos en otros lugares.
¿Cómo dice, señor?
Keep your voice up. Speak louder.
Y nos movemos en otros lugares. Cada vez que terminamos la casa, vamos a otras casas.
¿O en construcción?
Sí, pues no tenemos un trabajo estable, nos movemos a otros lugares.
I work in construction, fixing houses, and we move all over the place, depending where there is, where can we fix a house.
Right. Well, you got that ticket and then you never showed up for court.
Bueno, le dieron esa multa y usted nunca se presentó en el tribunal.
Until you got another ticket for the same thing, driving without a valid license.
Hasta que le dieron otra multa por manejar sin licencia de manejo.
Then you ended up spending a night in jail.
Y se quedó una noche en la cárcel.
At one point, you had tried to tell me, well, you did tell me that you had a valid Mexican driver's license.
Y después me dice que tiene usted una licencia válida de México.
Sí.
But you don't live in Mexico. You've moved here to Michigan.
Pero usted no vive en México, usted vive aquí en Michigan.
And when you move to Michigan, you need to get a Michigan driver's license.
Entonces, si está usted viviendo aquí en Michigan, tiene usted que tener una licencia del estado de Michigan.
The problem is you can't get a Michigan driver's license because you don't have lawful residency status.
El problema es de que usted no puede tener una licencia de manejo válida porque no tiene usted un estado legal aquí en los Estados Unidos.
So you can't drive and I can't fix it.
Entonces usted no puede manejar y yo no puedo ayudarlo a solucionar su problema.
Do you understand?
¿Entendió?
Sí.
Yes.
I saw they did have someone bring you here today.
Yo vi que alguien lo trajo hoy aquí al tribunal.
The fine for this offense is $100.
La multa es de $100.
There's a $50 minimum fee that goes to the state of Michigan.
Otros $50 para el estado de Michigan.
A $75 crime victim right fee.
$75 para las víctimas de crímenes.
And a $150 attorney fee.
Y $150 para la abogada del tribunal.
You did post $100 of bond.
Usted puso una fianza de $100.
So the total fine with attorney fee and costs is $375.
Entonces, en total son $375 de multa.
You posted $100 of bond.
Pagó una fianza de $100.
Which will apply to your fine.
Eso se lo vamos a descontar de sus multas.
So you owe $275.
Entonces, todo lo que debe son $275 en total.
Can you pay that today or do you need time to pay it?
¿Puede pagarlo hoy o necesita tiempo para pagar este dinero, señor?
¿Lo puedo pagar hoy?
I will pay today.
Very good.
Muy bien.
Now you can't drive anymore, you understand?
Ya no puede manejar, señor. ¿Lo entendió?
Sí, está bien.
Yes.
I'd fix it if I could, but I can't.
Yo lo ayudaría si pudiera, pero no puedo.
Sí, lo entiendo.
I understand.
All right, Ms. Strong, if you take your client out to the counter, he can pay that fine and his friend can drive him away and we'll
Do you want
all,
me to take his paperwork?
please.
Entonces ya nada más vaya con la abogada, pague la multa y eso es todo, señor.
Gracias.
Thank you.
Morning, everybody. Once again, happy Super Friday. Welcome to TCF Live. Good to have you all with me today. If you're a channel member and you did not catch the pre-show after the show, go back and take a look at that. It was humorful. I think you'll enjoy it. Slower start this morning out in Courtlandia. Judge Middleton is obviously up and running. Judge Elmore just got up and running a little bit ago, but that's about it at the moment. They'll come online, though. It just takes time. But let's hang with Judge Middleton for a while.
Oh, está usted aquí en el tribunal.
We have several files regarding Narcisco Hernandez.
Tenemos varios expedientes del señor Narcisco Hernández. Yes.
In file 24, 2176 and 77.
El número de expediente 2421-7677.
The defendant got charged with driving without a valid operator's license.
El defendido le están imputando el cargo de que estaba manejando sin una licencia de manejo válida.
And leaving the scene of an accident.
Y se fue usted del lugar del accidente también.
Then he promptly failed to appear for his arraignment and a bench warrant issued for his arrest.
No se presentó a la audiencia de arraigo y el juez emitió una orden de arresto en su contra.
He's also charged with having no insurance for that incident.
También le están imputando el cargo de que no tenía usted seguro de su automóvil por ese incidente.
Similar to the last defendant,
es un caso similar al del otro defendido.
the defendant got a ticket a year later for the same thing.
El otro defendido le dieron una multa por lo mismo un año después.
And that was alleged that on December 2nd of 2025,
aquí dice que diciembre 2 del 2025,
he was arrested for operating while intoxicated.
Lo arrestaron por manejar bajo la influencia del alcohol.
And open alcohol in a vehicle.
Y el otro cargo, tenía usted una botella, una lata de cerveza abierta ahí en el coche.
And again, driving without a valid license.
Y de nuevo, estaba usted manejando sin licencia de manejo.
You're here with your lawyer, Mr. Luke Knopfinger.
Está usted aquí con su abogado, el señor Luke Knopfinger.
And he tells me that the case has not been resolved. And he asked me to set this for a further pretrial.
El abogado me está diciendo que su caso no ha sido resuelto y está pidiendo otra audiencia para resolver el caso.
Some of these matters are charged under state statute.
Todos estos casos se resuelven bajo los estatutos del estado.
And some are charged under city ordinance.
Y otros de los cargos son bajo las ordenanzas de la ciudad.
So there are two different prosecutors involved in the case.
Entonces hay dos fiscales diferentes involucrados en sus casos, señor.
Mr. Knopfinger, is it correct that you're trying to resolve all the cases together?
Su abogado, señor Dastinger, me dice que usted quiere resolver todos los casos juntos. ¿Es cierto?
Sí.
Yes.
And you would ask me to set this for a final pretrial to try to resolve all the cases.
Y me está usted pidiendo una preaudiencia para resolver todos los casos pendientes que tiene.
Sí.
Yes.
All right, we will set a final pretrial on a Thursday afternoon.
Muy bien, vamos a darle otra audiencia, una preaudiencia el jueves en la tarde.
I don't yet know what day that is.
No sé qué fecha es todavía.
But it will be on a Thursday afternoon at 2:00.
No sé la fecha, pero va a ser un jueves a las 2 de la tarde. Okay.
Do you still live on West Street?
¿Todavía vive usted en West Street?
Sí.
Yes.
All right. I want you to stay in contact with your lawyer. We're going to schedule a pretrial probably in March and try to see if we can resolve all these cases at one time.
Bueno, por favor, manténgase en contacto con su abogado. Parece que la preaudiencia va a ser en marzo para resolver todos los casos pendientes que tiene.
He needs to get fingerprinted. Did he get printed?
Le tienen que sacar, le tienen que tomar sus huellas dactilares. El juez está preguntando que si ya le tomaron sus huellas dactilares.
No.
We also need to take your fingerprints on at least one of these cases.
Tenemos que tomarle sus huellas dactilares por uno de los casos.
We'll do that right now.
Eso lo van a hacer en este momento.
All right. The court officer will come out and they'll see that your fingerprints are taken.
Ahorita se va a presentar un oficial con usted y por favor vaya con él para que le tomen sus huellas dactilares.
Caitlin, it's on the fail to stop at a personal injury accident case.
Ese es porque... Eso es porque no se presentó a la... se fue de un lugar del accidente, dice el abogado. El juez, perdón.
Do you understand that you can't drive?
¿Entendió que no puede usted manejar, señor?
Oh, I'm sorry, Judge. Sí.
Yes.
Put that one on the top. All right, you're good to go.
Muy bien, ya está listo, señor. Ya se puede ir
This is continuing. All right, well, let him go. All right. Pablo, we had one more interpreter case.
Okay.
Rogelio Martinez Alamanza, and that case is being adjourned by stipulation. And that's filed 252704 ST. That case is off. So it'll probably be adjourned to March 6th. All right. All right, that finishes our morning. Hope your car's warmed up by now. I'll see you next time. Sorry you didn't get a trip to Centerville this afternoon because Jenny told me you were going to bring donuts from Yoder's.
Yes.
But I understand that case settled, so you can bring them next time, okay?
Thank you, Your Honor.
All right, thank you.
All right, bye-bye.
All right, we had a very troubling trend in 2024 and 2025 of young Mexican men being arrested for drunk driving. About a third of last year's cases were young Mexican drivers, often with an accident. And that looks like we're in the same pattern into the new year. All right, we have a number of cases up here, and I thank you for all your patience. We finished the interpreter cases, which take a long time, 3 times longer. So let's I don't have Luke. So let's take Howard's case. Austin Zablocki. Tried to do the Montauk cases last, but we'll move ahead today. Good morning, Mr. Zablocki.
Morning.
This is file 251711OT. Mr. Zablocki and I spent a lot of time together working on things, sometimes with success, sometimes not so much. This charge alleges driving suspended on August 19th of 2025. It's charged under Constantine City Ordinance. Hello, Mr. Levine.
Your Honor.
I'd like to see you before you leave. I forgot what you look like. Nice to see you in person.
I'll stop it.
Okay. He and I go all the way back to assistant prosecutors in 1980. At any rate, Mr. Zablocki, this charge is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. You've been having some ups and downs, and how are you doing these days?
Not too bad. Just working.
Where are you working?
Barlow Boats.
Which is where?
Bristol, I believe it is.
So you got to get from Culver Road to Bristol for work?
Yep.
It's hard to do when your license is suspended.
I have a buddy of mine who works there, so he gets me back and forth.
That helps. Ms. Montauk, I guess I'll defer to you. What's the status here?
Thank you, Your Honor. Mr. Bush and I have been working together to try to resolve Mr. Zablocki's case. The main goal that we're trying to work towards is Mr. Zablocki getting a driver's license. To that end, since the last time we were at court, he has made a lot of progress in terms of getting information together that will ultimately need to be submitted to the Secretary of State. He's been attending AA meetings. He has a book of meetings he's attending. Each time he goes, he writes a paragraph about what it is that he learned. He's gotten a drug screen. He's filled out the first part of this petition that needs to be submitted. The last thing that needs to be done is he needs to get an assessment. That costs some money, so there was a little bit of a hold back on that. But the hope is that now he can get an assessment, and that by the time we come back here, if Your Honor grants a final pretrial, then we will have a hearing date with the Secretary of State, and that will help Mr. Bush and I to resolve this.
I tried to get Mr. Zablocki an interlock in sobriety court. We had some stumbles, but Austin, I'm really pleased to see that notebook you got there. Part of the problem is you were not mature enough at that time to do what we were trying to do. I think you've grown up some, and maybe you can get this accomplished. The problem is, Montauk, this is going to take a while. So I can set a last pretrial, but we better set it out a little ways.
Well, the hope is that what I've been finding is that, because I do Secretary of State hearings as a matter of my practice. And so what I'm finding is that once we submit the documentation, it's taking about a month or two to get the hearing date. Yeah, it's not very long. So the real holdup here is the assessment. I don't think that will take more than a couple of weeks to get an assessment date set. So maybe, a month or two, I think.
All right, I'll say set at least 60 days out. Is that acceptable to you, Mr. Bush? Is that acceptable to you, Mr. Bush?
That is correct, Your Honor. I think this is a good resolution.
Mr. Bush has represented the village of Constantine for 50 years or more. And his philosophy, like many of the other prosecutors, is to try to help people get their license back. So Mr. Zablocki, there's some good news here. Maybe we can accomplish this. We'll set this no sooner than 60 days from today. And we'll see you on a Thursday afternoon at 2:00.
Thank you.
All right. Thank you, Mr. Bush. I need Luke on a couple of these. Let's see what else I've got here. Mr. McLaughlin, let's take your case. You got just one. Nice to see you this morning. Mr. Westcombe, would you come up and have a seat?
Mr. Whitcomb?
Mr. Whitcomb, yes. Mr. Westcombe is somebody else. Thanks. All right, maybe we can go a little faster here if the judge wasn't so slow. Good morning, Rhonda.
Good morning, sir.
All right, as I indicated, we got a lot to do this morning. We ended up sort of stalling out a little bit at the beginning, but I think we can pick up the pace. Deputy Myers is here. She's ready to go. Yes? Who's Romero? Who's his lawyer? Yeah, that's fine. Well, let me see if he owes me any money.
Well, Judge racks up the next contestant. Once again, good morning, everybody. TCF Live, good to have you here. It is a slow morning out in Courtlandia at the moment. It looks like some courts are ready to possibly start their day. I've got an eye on Judge Elmore, not any more or less compelling than what we have here at the moment. So we'll stick with Middleton for just a little while and then probably move on.
We had about 200 of those last year. As I mentioned, a lot of them were young Mexican men, and it's not a good trend. Operating while intoxicated is a misdemeanor for everybody here that's got that charge, punishable by up to 93 days in jail and a fine of up to $500. Carries 6 points on your driving record and requires that your license be suspended. They indicate that on January 10th at about 3 o'clock in the morning, you got arrested for operating while intoxicated right outside of town here, M86 and Strobel Road. You're here with your attorney, Stephen McLaughlin, and he's discussed this with the prosecutor. And they've agreed to reduce this to a charge of impaired driving. Is that correct, Mr. McLaughlin?
That is correct, John.
Impaired driving is better for several different reasons, but the main reason is it allows you to keep a restricted driver's license to drive back and forth to work. Impaired driving is punishable by up to 93 days in jail and a fine of up to $300. Carries 4 points on your driving record rather than 6. You have a valid license presently. You even have a chauffeur's license. A restricted license would allow you to drive back and forth to work and in the course of work. You had a suspended license in the past, but it appears to be valid now. Do you understand?
Yes, sir.
And do you understand that by pleading to this charge, you'll be giving up all the rights here on your advice of rights?
Yes, sir.
All right, let's take a look at this. 3 o'clock in the morning, January 10th was a Friday into a Saturday morning. There's nothing in here but the ticket. Were you driving a car on M86 at Strobel? Were you going toward Three Rivers or toward Centerville?
Towards Three Rivers, Your Honor.
Where are you coming from?
I was coming from Orland. It was the night of the 1st. It was January 1st.
Oh, yeah, it wasn't the 10th. It was January 1st. So it was New Year's Eve.
Yes, sir.
How'd you end coming from Orland, going to where?
My mom lives in Orland. That's where actually I grew up at. So I had stopped out and seen my mom and a friend that lives around the block. And then I slowly started making my way back. And I blew a tire at the bridge out here, headed towards Three Rivers. I live in Three Rivers.
Okay. Says you live in Borough, but now you live in Three Rivers.
I live in Three Rivers, yes, sir.
Well, that's a twisty turning way to come from Orland to Three Rivers.
It's just, it was like really snowing really bad. I just stayed on the main roads. Well, I came the back way from Orland.
Yeah, that's what I meant. All right, what were you drinking?
I had, Budweiser.
What was your blood alcohol level, Mr. McLaughlin? Do you know?
It is. It's a 0.12, Your Honor.
All right, we're gonna set this for what's called screening and sentencing. When we have a drinking driving case, we have to get some more information about you, about where you work. And so let's pick a day. We try to do these on Mondays, Mr. McLaughlin. Let's see what fits for you. How about Monday, March 16th at 11? Does that work for you?
Yes, Your Honor.
All right, Mr. McLaughlin, I'll have you take your client out to the counter and get the notice for that screening and sentencing date.
Okay.
And touch base with the probation department. We need to get his correct info. I think it shows he lives in Baroque.
Yes, we'll get that.
All right, thank you.
Judge, can I approach her?
Yes.
For a second? Just, yeah, just don't leave.
Kevin Reingart, the prosecutors agreed to dismiss it in exchange for restitution. He's got bond sufficient to cover restitution. Is that something we can take care of internally in that?
Yeah, we'll do it. No, I would do it on the record.
No, I mean, can we?
Yeah.
Internally, we can just do it now. You can tell the clerk to do that. They'll
Yep.
take the restitution out and take care of it. Okay.
Yes.
All right. Sounds good. Thanks.
All right, Mr. Moore, let's take your, do you have just one today?
Two. One's a civil correction. Actually, Your Honor, I had two.
Oh, you have another one?
Yeah, Mr. Barajas.
Oh, Mr. Barajas. Sorry about that. I got so many cases up here. Why don't we do him too while you're here? Go ahead and have a seat. Thank you. This is file number 26-530T. This is a Sturgis. Yes, ordinance case. You got charged with leaving the scene of a property damage accident. That's a misdemeanor. It's punishable by up to 90 days in jail, fine of up to $100, and it carries 2 points the way it's charged here. Your lawyer has worked out an agreement with the prosecutor where you will plead to a charge of leaving the scene of an accident with a fixture, which is something like a fence post or a fire hydrant or a sign. That doesn't carry any points. It's a 0-point offense, but it is a misdemeanor. Do you understand?
Yes.
Mr. McLaughlin, you agree that's the plea agreement?
Yes, Your Honor.
Anybody threaten you to get you to plead to this?
No.
Promise you anything?
No.
All right, and you're giving up all the rights here on this advice of rights?
Yes.
Let's take a look here, Mr. Barajas, see if you'll record any money. All right, well, tell me what happened.
I was on my way to work and hit a patch of ice and
You hit a what?
a patch of ice.
Okay, and then what did you hit?
And then I hit mailbox.
All right, and that's probably fixture.
Yeah.
This was at 5 o'clock at night, cottage and 4th Street in Sturgis. So what did you do then? You just kept driving and went home?
I took it to a friend's house down the street. I just left her there.
Nice car, a 215 BMW. How much damage did it do to your car?
In total.
The total of your car?
Well, yeah, it did. It did. Because the insurance is a third. If it's a third of the cost of the car, then it's technically total.
There must have
And
been some.
the parts are expensive.
We often think these are drunk driving cases that got away. But this is 5 o'clock at night, not 5 o'clock in the morning. And there's no indication of anything else. So I'm just gonna fine you $100 plus costs and the matter will be done. As I said, it doesn't carry any points. There's about 10 different ways to charge failing to stop or report an accident. And some have different. So one time I had a copy of all of them. Accidents to fixtures is 257621. Also carried, it used to carry a driver responsibility fee, which was $500 a year for 2 years. Thank God we've done away with that. All right, the fine's $100 and there's 75 and 50 in state costs, so the total is $225. Can you pay that today or do you need time to pay it?
I need time to pay it.
Well, I'll give you 30 days. We'll make that due by
Yeah, that's fine.
March 6th. Is that enough? There's instructions on how to pay with a credit card. You can pay with green cash, certified check or money order. The court's address is on it, but all right, you're good to go.
Thank you.
In Missaukee County, however, I'm here in Washington County on the bench. We're going to take up 2 files. Each file is entitled People of the State of Michigan versus James Kerr. First case number is 22-3284FH. And the second file is 22-3285FH. Appearances begin with prosecutor.
Thank you, Your Honor. David Denhout on behalf of the people.
Good morning, Your Honor. Bernard Jockins, appearing on behalf of the defendant. I'm appearing at the grace of the court by the Zoom application, and my client is also appearing on the Zoom application.
All right, Nancy, if you can't see that, it's Jockums, Jocuns. All right, folks, thank you very much. Also joining us today via Zoom from the Gladwin County Jail is the defendant, Mr. James Kerr. Mr. Kerr, are you able to see and hear the court?
Yes, I can see the courtroom.
All right, good enough. All right. Here today for a alleged bond violation. And it looks like we had an initial show cause or arraignment back on January 30th. The court ordered that the defendant would be held without bond. There was a withdrawal of counsel, Barnett, who actually hadn't appeared on the case, I don't think, in a couple of years. And then we got Mr. Jockums, who has now come on to help us today. Let me find the allegation here, just a moment. All right, looks like there was a amendment to his bond. I signed that back in June 26, 2024. Like he had been allowed to attend treatment back in 2022, then had been allegedly in an absconder status since. Mr. Jockins, how does your client wish to respond to this today? Are we going to have a contested hearing or what?
No, Your Honor, and this is what's going on today. He's going to be acknowledging responsibility of the bench warrant and the violation, and it's going to be part of a global resolution.
All right, so we anticipate a resolution today to the case, Mr. Denham?
That's correct, Your Honor.
Okay.
Your Honor, opposing counsel and myself, we've been communicating over the last 2 days, and it's my understanding that to resolve both cases, which involve the underlying narcotics found at 2 traffic stops. In any event, to resolve both cases, it's my understanding that the defendant will be pleading guilty to use of methamphetamine, that being a maximum 1-year misdemeanor. It may make sense to enter that. I have no particular preference, but it may make sense to enter that in 223284 because the underlying charge was possession of meth in that particular file. And then the other file would be dismissed. And as part of this global resolution, as opposing counsel has indicated, there will be an acknowledgement that he failed to return as required by the prior court order.
All right. So I'm just going to make sure I've got that all correct. In file 3284, the defendant is charged with possession of meth as a 3rd habitual felony offender. Both of those will be dismissed if the defendant enters a plea of guilty to the lesser charge of use, which is a misdemeanor.
Yeah, that's correct.
And then in addition to that, if that happens, then in file 3285, where the defendant has a charge of possession of an analog, operating a license suspended, operating a vehicle with an unlawful plate, as a 3rd habitual offender, that will all be dismissed.
That's correct.
All right, Mr. Jockins, is that what you understand, sir, today as well?
That's an accurate statement, Your Honor.
All right, Mr. Kerr, have you heard what the attorneys have described to me as the resolution today?
Yes, Your Honor.
All right, is that how you wish to resolve today's case or cases?
Yes, Your Honor.
Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, Your Honor.
You may lower your hand. All right, well, these cases came about a few years ago. We're going to talk about the charges and the pretrial agreement in just a moment. Mr. Kerr, however, we need to go back over and talk about the bond violation allegation. Other than the terms of the pretrial agreement, which we've discussed today already on the record, have there been any other promises, threats, or inducements to get you to plead, or I'm sorry, admit responsibility to violating the bond conditions?
No, Your Honor.
Oh, okay, hold on, because you looked a little inquisitive there. I'm going to make sure I say it loudly enough so you can hear me. I
Okay.
understand that you're on a laptop. So part of today's resolution is not only the pleas, as I mentioned a moment ago, and the dismissals, but also that you're going to admit responsibility for violating your bond and being in an absconder status. Is that true?
Oh, yes, Your Honor.
Okay, thank you. Has anyone forced you to do this, compelled you to do it, put a gun to your head, threatened to beat you up or anything like that?
No, Your Honor.
All right, so you're making this choice of your own free will today, sir?
Yes, Your Honor.
All right, therefore, I'm going to ask Mr. Kerr, is it true that you violated your bond and you've been in an absconder status now for the last couple of years?
Yes, Your Honor.
All right, thank you. All right, the court finds the defendant in violation of his bond. Technically, the court revokes his bond and remands him into custody. Next thing, Mr. Kerr, is we're going to talk about these pleas in these two cases. Are you able to hear me clearly?
Yeah.
Do I need to speak up louder?
No, they're just doing dishes or something. There's water spraying too. I can hear you pretty good.
All right, thank you. All right, sir, there are two files. The first file is file number 3284. In that case, you are charged with a single count of possession of methamphetamine. Now, that initially is a felony punishable by up to 10 years and or up to $15,000. Plus, there is a sentencing enhancement called a third habitual felony offender. And what that means is if you were convicted with that on the charge sheet, within the discretion of the court, that maximum punishment could be increased from up to 10 years to up to 20 years, and from up to $15,000 to up to $30,000. However, all of that will be dismissed today if you enter a plea of guilty to an added count 2. Added count 2 would be a charge of use of the controlled substance methamphetamine. Now, use is a misdemeanor. That is punishable by up to 1 year and or up to $1,000. You understand?
Yes, Your Honor.
All right, thank you. Now, I keep in mind here for you that if you were to be picked up and charged or convicted of some other drug case, this conviction for a use could also be used against you to increase the potential punishments on any future drug case. Now, by the way, when I say that, I'm not trying to suggest that that's going to happen to you or that you're going to go back to using controlled substances, but I just want to make sure you understand how it could impact you in the future. Do you understand so far?
Yes, Your Honor.
Now, in the other file, file 3285, you are charged with 3 criminal offenses. Count 1 is possession of a controlled substance. Specifically, it's called an analog. An analog is a controlled substance that's derived from a controlled substance, but it might be made into a medication. And this one is diazepam. Now, that's a felony punishable by up to 2 years and or up to $2,000. Plus, again, there is a third habitual felony offender enhancement. That could, within the discretion of the court, allow the court to increase that potential punishment from up to 2 years to up to 4 years, and from up to $2,000 to up to $4,000. Count 2 is operating a vehicle while your license is suspended, denied, or revoked. That's a misdemeanor punishable by up to 93 days and up to $500, plus vehicle mobilization. And count 3 is a charge of unlawful use of a plate on a vehicle. That is a misdemeanor punishable by up to 90 days and or up to $100. However, all of that will be dismissed if you enter that plea of guilty to the added count 2 of use in the other file. You understand so far?
Yes, Your Honor.
Now, by entering a plea of guilty, if this court accepts that plea, you will be waiving certain rights. Now, that includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify at a trial if you're to choose to testify. Do you understand those rights, Mr. Kerr?
Yes, Your Honor.
And even more importantly, do you understand that if you plead guilty and I accept that plea, you will be forever waiving those rights as they apply to these particular cases?
Yes, Your Honor.
Additionally, any appeal as to the conviction and sentence pursuant to this pretrial agreement would be then by filing an application for leave to appeal and not a claim to appeal by right, which is only entitled to a defendant when they are convicted after a trial. Or you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You will also be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me right now on the record. Have there been any other promises, threats, or inducements to compel or encourage you to plead guilty today that we haven't talked about?
No, Your Honor.
Are you entering the plea of your own free choice?
Yes, Your Honor.
Now, I understand that Mr. Jockins has come in to help you a little bit here at the end. Have you been able to speak with him about the charges?
Yes, Your Honor.
Have you been able to speak with him about the pretrial agreement?
Yes, Your Honor.
Has he been available to answer all your questions for you?
Yes, Your Honor.
And are you satisfied with his counsel thus far?
Yes, Your Honor.
All right. Now, we're going to talk here in a minute. There's probably do sentencing. Well, anyways, I'll look into it. Has anybody made any promise to you or suggested to exactly what the what the sentence would be from this court?
No, Your Honor.
All right. Do you still wish to enter the plea of guilty that we discussed earlier?
Yes, Your Honor.
In file 3284, as to the added count 2 of use of methamphetamine, a misdemeanor punishable by up to $1,000 and up to a year. How do you plead?
Guilty.
Before the court can accept that plea, I need to have you tell me what you did that makes you guilty of that offense. So I'm going to turn your attention almost 4 years ago now, 3.5 years ago, back to August 5th of 2021, over in Richland Township in Missaukee County. Were you stopped out on West Falmouth Road, looks like by a deputy?
Yes, Your Honor.
All right, and were you driving a car? Were you a passenger in a car?
I was driving.
All right, and when that officer was there, did they find some methamphetamine on your person or within your area of control?
Yes, Your Honor.
Tell me where it was.
It was like right. I was using it. It was on my lap.
Okay, and so when you said you were using it, how were you using it?
Smoking it.
Okay, and did you know that what you were inhaling or consuming was the controlled substance, methamphetamine?
Yes, Your Honor.
All right. I always find this next question, and I don't mean to be rude, a little bit comical because technically methamphetamine, I think, is used for 2 or 3 medical issues somewhere in the world, but I don't think you have them. Did you have any lawful right to be consuming or using that controlled substance that day?
No, Your Honor.
All right, thank you. Mr. Denon, you believe the defendant provided a factual basis?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
You believe the court's in compliance with Mission Control 6.302?
I do indeed, Your Honor.
All right, Mr. Jockins, do you agree with all 3 of those?
Yes, Your Honor.
Thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the testimony provided by the defendant under oath on the record satisfies the elements for added count 2 in file 3284. Therefore, the defendant is found guilty of that count for use of the controlled substance methamphetamine. The remaining count 1, and the third habitual enhancement will be dismissed at or after the time of sentencing. At the same time, the court will dismiss the counts alleged in file 3285. Now, the next question is, can we proceed to sentencing? And what's going to help me make up my mind is, Mr. Jockins, can you tell me, is your client serving a jail sentence? Does he have another charge over in Gladwin? That'll help me make a decision.
To my understanding, Mr. Kerr is serving a sentence in which he has a cap that might be 1 year, but I believe that Mr. Kerr, if he is asked directly, he could tell the court exactly what that sentence is, Judge.
All right, thank you. Mr. Kerr, can you tell me, for what are you serving a sentence? What's the conviction?
A fleeting and eluding, I have to March. March is my next court date, and I took a deal here trying to clear up all my warrants for every county and take responsibility for all my actions. And I took a deal here for 1 year cap. Just waiting on them, and my next court date is till March.
All right, thank you. All right, so that means, at least I interpret what you're telling me, is that you have not yet been sentenced, but you have entered a pretrial agreement in which there is an agreement that there would be up to 1 year, or what other people will call as a 1 year or a jail cap. Is that correct?
Yes, Your Honor.
All right, thank you. Mr. Denham, any objection to proceeding to sentencing?
No objection. I would be prepared to proceed today.
All right. Now, Mr. Kerr, I can't proceed with sentencing in this file right now. However, before I do so, I need to ask you a question. Every defendant has the right to be in front of the court when there is a sentencing. However, you are able to waive that right and allow us to conduct sentencing right now via Zoom. Do you waive that right to be physically present, or do you want me to send somebody down to pick you up and drive you over there?
No, Your Honor, I don't want to waste the court's time. I waive that right.
All right. Mr. Jockins, any objection to that waiver?
No, Your Honor.
Thank you. I find that the technology is appropriate and permissible underneath the court rules. Mr. Denham, your recommendation on behalf of the people?
Yes, Your Honor, thank you. Your Honor, the two cases involve two separate traffic stops within a few days apart, each finding narcotics. There was nothing exacerbating about the traffic stops themselves. There was no resisting or anything. So he was cooperative at the scene, and some time has elapsed. I believe initially he left because he had a medical condition. In any event, the people are not requesting a period of probation. We believe that it would be duplicative based upon the plea that's been entered in another county. We would leave any jail term to discretion of the court, Your Honor.
Thank you. Mr. Kerr, do you still live over in Taylor, or where are you living these days?
I'm Gladwin, but I plan on moving out of state once I'm out of here because my dad just moved out of state. That's why I'm trying to serve jail time for it.
No problem. All right, I'll listen to you in just a moment. Mr. Jockins, anything in allocution?
Your Honor, this is a unique situation because usually somebody that has multiple charges and multiple warrants at the same time, a lot worse things can happen in 4 years. He absconded for 2 years. I talked to him about this yesterday, and he was scared. He was trying to get by. He was trying to make money. And, from initially, I believe that there was a medical issue, and he maybe a credit for the time that he's already been served, as he's going to be serving about another 10 months or so in the Gladwin County Jail.
Thank you, Mr. Jockins. Mr. Kerr, before the court issues a sentence, you have the right to be heard. Is there anything else you wish to say today, sir?
I would just like to say I accept responsibility for not coming back. I had spinal fusion. I'm even Gladwin's got me going to do a brain scan, so I got a lot of medical issues, and I'm trying to, you know, push through it and accept responsibility for my actions and my actions alone. And thank you, Your Honor.
Thank you. Court recognizes initially today that, hold on. This is a conviction for a misdemeanor. The law requires the court to begin with a presumption of just fines and costs, no jail and or probation. The court, however, does find reasonable grounds to give a jail sentence. That reasonable grounds is based upon the defendant's prior criminal history that I can see here on the felony informations in both files. The fact that he has multiple cases going on at the same time. Also that he's been picked up on a flee and elude in Gladwin County. Plus the fact that we had sent him to rehab and then that's when he absconded. The court therefore sentences the defendant in file 3284 as follows: a $50 state minimum fee, a $75 crime victims' right fund fee, a $100 court cost for the processing of the case. Mr. Jockins, again, you accepted this as an appointment, is that correct?
That's correct, Your Honor.
Court assesses a $300 attorney fee. The court also assesses a $100 fine. Because there is no supervision, the court does not obviously order any supervision fee. As for a period of jail, the court, considering that he has a gap in the other case. Well, hold on, Mr. Kerr, when did you get arrested, sir? Or, when did you get arrested?
In Gladwin?
Yes, sir.
It was 2024, an old fleeting and eluding warrant.
Yeah, but when did you get arrested? How long have you been in jail is my question.
Beginning of it was December 27th.
Hold on just a moment. Let me take a look here.
It was like the beginning, or I've been here for, I don't even know what today is. I've been here about a month, I'd say.
All right, 1 second.
All right.
All right. The court sentences the defendant to a jail term that will run concurrent to whatever other sentence he is currently serving or about to be served. I'm sorry, ordered by the other court. That is, again, of course, if the other court complies, it's up to the judicial discretion of that judge. But the court sentences the defendant to 150 days, and so far, I am counting 26 days of credit. For the record, in case it ever comes up, I see that in this original file, 3284, the defendant was arrested on January 29th of 2022. The court allowed that he be released on February 17th of 2022. Therefore, in that year, he had 19 days, and thus far, because I conducted the arraignment on the 30th of January and up to today, that's an additional week. Therefore, that gives the defendant the 26 days. Now with good time, and I'm not, hold on, for good time, 1 second. If I'm correct, that means the defendant has 99 days left to serve on this particular file. It is the intent of this court to sentence you in a way that allows you to serve them concurrently and get out at the same time, or at least this hopefully shouldn't block you getting out. I don't know if that makes sense, but it does to me. Mr. Jockins, do you have any questions about the sentence here of the court?
No, I do not, but I would like to give my email address to the court clerk so I could get a judgment of sentence, if that's okay, Your Honor.
Yeah, go right ahead, sir.
It is my first name, Bernard, B. O as in Oscar. S as in Sierra. Yes, Your Honor.
All right.
US
So I'm a retired lieutenant colonel. All right. Anything further today, Mr. Denham, on behalf of the people?
No, Your Honor.
Mr. Kerr, do you have any questions about the sentence today?
Will I get like paperwork mailed on how much I owe?
Yes, sir.
All right, thank you, Your Honor. No more questions.
All right. Thank you. We're adjourned.